isn't it?
Indeed, my lord.
Thank you.
May it please the court, my lord, I appear for the second applicant. My name is Mugia A.
Yes, thank you.
Yes, my lord.
For the respondent, my name is Jabim about the case, Mr. Elbasu.
Yes, thank you.
My lord, I'm making a brief application.
Yes, Mr. Mugia.
The request, my lord, and the indulgence sought is that the matter be briefly stood down for 20 minutes. The lead counsel, that is Professor Maduku, 5 minutes ago, and they assured me that he is just about to arrive. My lord, I apologize for the delay.
State.
The state is moving forward with that division.
I just assumed that you are in agreement with Mr. Judicial.
Indeed, my lord. Indeed.
You say 20 minutes?
20 minutes, my lord. Right into the minute.
The court will adjourn until 11:15.
With the Honorable Court is so pleased to resume the matters of Moses Mpofu from the state and Mark Chimombe of the state.
May I please stand and thank the court for the indulgence that was granted.
Very well, Mr. Mpofu. Yes, just for the record, we shall hear the two bail applications at the same sitting. So whatever deliberations, evidence or facts that will, to the extent that they are relevant to the accused persons, apply to both cases. Thank you. Yes, how do we approach this matter?
My Lord, the state had raised a point in the meaning which will determine how this court is going to proceed. The state insists that this should be an application on changed circumstances, and defense is of the view that it should be a fresh application. The state then raised the point in the meaning on that issue, whether the application which has been filed by the accused persons, by the applicants, is competent.
Okay.
So it is paramount that the point in the meaning be determined, and this determination will then determine how the main application will be dealt with.
So you are saying the state considers this as whether the application is competent?
Yes.
And you are saying the state considers it to be?
The applicant that has been filed is incompetent.
Yes, on the basis that?
That there is an extant judgment denying the accused person's bail. And therefore, in terms of the law, bail proceedings, they constitute part of the record of the trial. And therefore, the bail application in the lower court is part of the record in the main trial. Those proceedings, that application is there by operation of law. So therefore, the state would like to motivate its point in the meaning that it is raised.
Are you concerned with the naming of the application, whether it's a bail application, whether it's an application, as you say in your response, based on changed circumstances, or a fresh application as the applicants you are concerned with the way it has been named, the name that has been attributed to it?
My Lord, the state would like to submit that there are different types of bail. Fresh bail application, bail on changed circumstances, reinstatement of bail. All these type of bails, they they have different considerations, they have different factors that are taken into consideration. So it is very important for the proper application, bail application, to be properly identified. You cannot say bail application because there are different types of bail applications which an accused person may encounter during the process of his trial.
Is a bail application made in terms of any other law other than 117A?
There is one in terms of section
116.
There is the one that is listed is concerned is section 116, sub 116C, which talks about bail on chain circumstances. It is specifically provided for by the law.
I understand. What I'm saying, what I want you to address me on, perhaps, is that every bail application is made in terms of a law, isn't it? In terms of a law. What is the law which governs the form of a bail application? I mean, which allows an accused person to make an application, in terms of which an application is made. I am aware of 116.
Yes.
Is it C, which speaks about a further application. It does not speak of an application based on changed circumstances. That is case law. But it speaks of a further application. So, is that further application made in terms of any other law other than 117A?
Well, 117 large A is basically the one which gives the court the procedure in bail application.
No, it is. Well, I'm sorry for saying that. Maybe we have something more to say, but I understand it to be the law which allows an accused person to make an application.
Yes.
It may be 1, it may be 2, it may be 3, it may be 4, but each time the application is made, it's the law which allows the accused person to do so is section 117A.
Yes.
But of course, 116 may be relevant to the dispute between the parties as to whether this is a fresh application or it is a further application. I always discourage lawyers from using the word application based on changed circumstances because we are really legislating. The law is that it's a further application. Let's call it that. Maybe judges, in giving effect to section 116, may have used certain words. They may, I'll say we, in the sense that I'm a member of the High Court bench. We may have used words like changed circumstances, but it's not always a situation where there's changed circumstances. It may be a new factor coming in. So I'm simply trying to say that we have this, we may slip and start attributing names to applications which are not in the statute. 116 is simply saying a person cannot, I think they use the word cannot make an application in situation where a previous application was determined unless it is based on new facts. But whatever application is making, it has to be an application which he is able to make because section 117A allows him to make that application. So I'm just looking at it with a magnifying glass. Are we saying a person may not competently make an application? Is he disallowed? What then do we do? Do we strike it off? Because if it cannot be made, then we strike it off. My view, if I must tell you why I'm raising this, is that it appears to me that in terms of section 117A, an accused person can make an application at any time. It's a question of what to take into account when dealing with that application. It's worded in very confusing terms, I understand. There is cannot. So does the court go into an inquiry as to whether or not there are new circumstances to consider whether that application is competent? Or the court hears the application then it considers whether or not there are new facts. Then it may then consider that, whether or not to grant bail. Does it bar an accused person from making an application? Which is basically the kind of objection you seem to be making.
Yes. The state's position, my lord, is that it is important to identify the nature of bail application which is being made. For example, there is bail application on changed circumstances. The understanding that the understanding of the state is that an application would have already been made, and there is a reinstatement of bail. In terms of section
Reinstatement? No, let's not talk about situations that are not affecting this matter.
yes.
I want to discourage you. I don't know whether I will succeed. You from using the word bail application based on changed circumstances. I see that very often. Okay. But I have written a judgment to say, let us not legislate. There is no bail which should be named bail based on changed circumstances. It's just a bail application. It is a further application, further to an application that was made before. Maybe that is an averment that can then be made inside the statement. But on the face of it, it is a bail application.
Yes.
Yeah.
Eventually, it's a bail application,
Yeah.
because one needs to be to go out of custody.
Yes. So it's a bail application. Then, if the accused person must always be mindful that if he has made an application before, which has been determined, they will not succeed unless they are. I'm just putting my understanding of your position across, what it should be.
Yes.
That fair enough, an accused person can make a bail application, but will he succeed if he was previously denied bail and there are no new facts? The answer is clearly, the law answers that question, no. Do you understand?
Yes.
So, but the application itself does not have to be named an application based on change. Because now we are really arguing over words used or nomenclature or what an application should be. But it's like, let me migrate a bit.
Maybe to simplify the issue. The issue which arises is the issue of honors. In a fresh bail application, the onus is on the state, except in respect of third schedule offences. In all other offences, it is the state which has an onus to prove that there are compelling reasons for the accused person not to be given bail. In terms of section 50, 1D, bail is a right in non-third schedule offences. But section 136, which is fraud, for which they are being charged, it is not a third schedule offence. Ordinarily, it will be the state that has the onus to prove that there are compelling reasons. But that stage has since gone past. The state has successfully done so. That's why the accused persons are in custody.
So the issue
Now, at
arises.
this stage, if it is a fresh application, is it the argument at law that the state has to assume onus again? But the state is saying no. It is not going to recall the witnesses and prove that there are compelling reasons. That has already been done. There is a record of proceedings before this court, which record speaks to what happened in the fresh application. And therefore, the state can only discharge that onus only once. So this is the stage at which the state finds itself that no, this cannot be a fresh application as the applicants are saying, because that would entail in the state having the onus to prove compelling.
Oh, you are saying, that's why you said that issue will resolve who begins?
Yes.
Okay.
It's the question of onus.
I saw that in your response that you are saying the onus is on the state to, or rather on the applicants to show that they are changed, they are new facts.
Yes. if they successfully establish that there are changed circumstances, then the state will then have the onus to prove, to disprove whether such changed circumstances exist. If it concedes that such changed circumstances exist, it will go on to prove that there are still compelling reasons
Okay.
to deny them bail despite the existence of compelled reasons, if that is its position.
I see.
Yes.
Thank you. I think you've made your position clear enough. Let me hear from the... Mr. Jetero?
Yes, my lord, thank you very much. I'm indebted to the exchange that the court has had with my brother here. But my brother did not clarify whether or not he is admitting that the application, as in terms of section 117, is a competent application.
No, he doesn't have to. You just need to make your submissions regarding what he has said. I was just saying, I just wanted him to be clear about what he means by the objection. Whether he's saying the application cannot be made. Because if he's saying the application cannot be made, the usual remedy is not in compliance with the law. The usual remedy would be to strike it off, isn't it?
Yes, my lord.
Yes. So I think he has made his position very clear. Clear enough for you to be able to respond. What are you saying to the objection that the application before me is incompetent, and also that we must I think he implies that the applicants must begin.
My lord, what I heard my brother to be saying is that we do not have honors. Honors and competence are two different things. If he is arguing that he does not have honors, it's an argument that he makes in the main application for bail, in opposition. To say, I don't think I have the honors,
Okay.
and
Like
therefore...
that. So you are saying honors and competence are separate issues?
Yes, my lord.
I'm just recording this as your response. I will not ask him to respond to I'm just recording this as your response to his objection.
Yes, my lord.
Yes.
Because if his argument is that I do not have honors, it cannot be a point in limine. It cannot be a preliminary point to say I do not have honors.
Okay.
So it then therefore means that his point is not a point in limine. It therefore determines the course of action that this bail application must take. Because if he admits that every bail application that is made to this honorable court is made in terms of section 117, it therefore means it is a competent application. And it therefore means that his point of whether or not he has honors cannot be determined first. That is the submission that I wish to make first, my lord. The second submission that I wish to make further to that, if you could just...
Sorry, you want to object to something?
I don't know whether the state was through with its application, its point in the main.
No, I thought you were. If you went, then you ought to have brought that to my attention before I gave Mr. Jetero the chance to respond. I honestly thought you were done. But if you still had further submissions to make.
Yes, the state was only responding to the issues that were raised by the court.
Okay.
Yes.
Okay. If you are worried about responding to what Mr. Jetero said, you obviously have the last say. But if I interrupted you and allowed the accused persons to respond before you had rested your submissions, I would think there's nothing wrong with you continuing with the submissions, Mr. Jetero. We always make slips. He's saying I prematurely allowed you to respond to the objection. He still had more submissions to make. Anything wrong with him completing his submissions?
He can complete. Maybe just to make it clear, I was just reacting to the...
Yeah, I thought honestly that you had rested your submissions. But anyway, you can proceed.
Yes. My Lord, Your Honourable says, my Lord, it is the state's contention that it is not in dispute that an application was made before the lower court, which application the applicants lost their application for bail was denied. Evidence was laid. The record is before this court. Now, it is the state's or respondents' view that the lower court's judgment denying the applicant's bail is still extant. It was never set aside by a judgment of this court or another superior court. Now, the accused persons, so the applicants, were then indicted. The effect of being indicted was that a warrant was issued by a magistrate, which meant that the applicants were to appear before the trial judge whilst in custody. But that warrant, in terms of section 66 subsection 2 of the Criminal Procedure and Evidence Act, chapter 9.07, did not set aside the judgment of the lower court denying the accused person's bail. That refusal of bail remained extant. Now, they then appeared before this honorable court because they were in custody. It is the state's contention that section 169 of the CPNE Act is not applicable to them because they are already inside. Section 169 of the CPNE Act, which invokes the further continuation of an accused person enjoying bail. If they were outside in that position, a clause in terms of section 169 was applicable to them, and they were then placed inside by operation of law, they could have applied for bail, for reinstatement of bail, because they were already on bail. And that could not have been a fresh application. That could not have been.
So they would have applied for reinstatement of bail in terms of section 169.
169. Asking this honorable court that they were out of custody by operation of law because they have pleaded to the charge, they have been incarcerated, made the old, they are still prepared to abide by the position which admitted them to bail in the law. That could have been done. I don't see my learned colleagues arguing that in respect of an accused person who is outside on applying for a reinstatement of bail or applying for bail, whichever term they intend to use, they would have made a fresh application, which would have entailed the calling of witnesses by the state. Now, the accused persons were already in custody, they pleaded to the charge, so that section was not invoked. They were in custody primarily because of having been denied bail. That section could not have been invoked to someone who is inside. You cannot say someone who is inside, you have pleaded, although you are inside, stay inside. That would not have been necessary. and the state would not even have enforced that the provision of that section, insisting that the court must remand them in custody. So, eventually, the applicants, after having pleaded to the charge, they are in custody as a result of the extant magistrate's court judgment denying their bail. The compelling reasons why they were denied bail, they were never wished away. They are still standing. The real risks that were proved by the state in the lower court, they are still in existence.
Thank you.
If the applicants are of the view that although they were denied bail because of certain compelling reasons, but now they believe that they deserve to be granted bail, they are supposed to come to this court and give reasons why. The reasons for which they've been denied bail no longer stand because of changed circumstances. This is the stage at which we are. The mere fact that they were flight risk.
So they must come to court and convince the court.
The court.
That convince the court of the judge that
the reason for which they have been denied bail by the lower court, they no longer hold water because of new circumstances which have arisen. So the position of the applicant is like an accused person who was denied bail and never appealed against that decision. They are the same. Both the one who tried to appeal against it never succeeded, and the one who said, I will abide by the decision of the lower court, will still be in custody for those reasons. So it is the same. So the one who never appealed against the decision of the lower court, if he, that accused person, intends to then apply for bail, he should be on changed circumstances. You cannot therefore apply for bail for a fresh application. The state will keep on insisting that that decision of the lower court cannot be wished away. That is a competent court whose judgment can only be set aside by a judgment of a superior court. That decision, because it's a competent court, it binds every person, every institution, and even this court. This court cannot disregard a decision of the lower court simply because it is a lower court. You cannot say, we are not bound by that. We want to start the procedure first. That is not how the justice system runs. It respects every tier of courts.
yes.
Yes.
Thank you.
So now that we are here, the court, it is the state's view that it proved that there were compelling reasons in an extant judgment, and therefore it cannot just disregard an extant judgment and say we are starting afresh. How can there be a fresh start when the record in this court, there are proceedings of a bail application which were incorporated, the proceedings which were incorporated in terms of the law. That record, which is part of the record of the trial by this court, cannot be wished away. So we cannot have two fresh bail applications by an accused person. Only one bail application. The rest they can go by whichever name, but it won't be the state which will be having the honors to prove that they are compelling reasons. The state can only prove that they are compelling reasons only once. Now, the applicants make an application before the court. I don't know whether they get. They said they were they got that suggestion from the registrar. I think they have to take it up with the registrar if they're the ones who entice them to make a particular.
Can I ask you something, Ms. Mabawudi? When a person makes an application in terms of section 116, is it 116 what?
116 C2.
C2.
Yes.
The further application.
Yes.
What is it?
It only tells. It only.
Is the accused precluded from saying it's a fresh application?
You can say whatever you want to call it, but it's only a fresh application. Because the fresh application.
No. What I'm saying is, what does fresh mean?
It means you never applied for bail.
No, it doesn't mean that. It doesn't mean that. You probably are arguing about the merits, isn't it? If an accused person makes an application today, isn't it?
Yes. And
he decides to start afresh, you can call that a fresh application. It's fresh. It's different from the previous one.
Well,
so that's why I say, that's why I'm saying I will always go back to my judgment. I don't remember which case it was where I said, let us as lawyers stop legislating, because we then end up interpreting our own law which we are writing. I'm also going to criticize the accused person for calling it a fresh application. They should have simply called it a bail application. So that we don't argue on whether or not it is fresh or what. I have a bail application before me. Then the law tells us what to consider in determining whether that application should succeed. In other words, we consider the issue of honors. We consider the issue of the facts to be considered. That is what you must be guiding me on. But in terms of the name, I totally disagree with both of you that you are entitled to call it by any name other than a bail application. It is a bail application. Whether, a person can properly call it a fresh because it's different from the earlier one. So you can call it an application based on changed circumstances, but you are not required to do so. The law talks about a further application. It doesn't talk about an application based on changed circumstances. That is case law. So why don't you both call it a bail application full stop? Then you argue on who has what honors, what facts should I consider. Those are the merits. Because we can't really be bogged down on the name. I don't want you to call it by any name because we would be legislating. The problem with calling it by names which do not appear in the statute is that we are supposed to be applying the law, isn't it? And the source of law is the statute, isn't it? Yes. So if we give these applications names that do not appear in the statute, we end up interpreting our own ways that we have used. Like now, we have really been arguing on whether it should be a fresh application. The legislation never spoke of a fresh application.
My Lord, may I suggest that
yes.
What the state is saying is it's an application based on facts which were not placed before the judge or magistrate before. This is the nature of the application.
Yeah, but it can't be called that. It is just a bail application. Then you can argue before me whether I must be what to consider in terms of. That's why I said, what approach do we take? Isn't it? You can then say to me in your argument, in opposing it, you can say, as you are saying now, bail has already been considered. The court has already found. I'm just trying to understand to say how I understand your argument to be. A competent court has already considered this bail. It has already made findings. This court is precluded from making, any new findings regarding what has already been disposed of, which remains extant. That's what you are saying, isn't it? Those are the merits. We don't have to be arguing the whole day about what to name it because you are not supposed to give it any other name. Just call it a bail application. It's just like a court application. I was about to tell you about a court application in civil. If a court application, a person has to make a court application, and for some reason it aborts, okay? When that person comes up with a further application or another application, they don't call it a fresh application. They just call it a court application. Then you state, you ground it on something. Now, in your founding affidavit, you then explain, but it remains, fortunately in civil, we've got a template there. We've got a court application, which every person must follow. Whether he has made an application before or not, he still calls it a court application. Then what you are there is something else in order to succeed. So now, but what we have happened here, I personally believe, maybe you can convince me otherwise, that both of you are legislating.
My Lord, I think the contention is
Yes.
the applicants had in the application, they say that the state has the honors. It has to call all the witnesses.
But is that a preliminary issue?
It becomes a preliminary issue because of honors. The preliminary issue is who has the honors to prove compelling reasons. The state is saying it has no, because if it is a bail in terms of section 116 C subsection 2, it is not the state which has the honors.
So is that what you want the court to determine now?
Yes.
Yes. So does that have anything to do with competence of the application?
The state,
I know that when honors is contentious, you can seek guidance of the court from the beginning. Because then you say, we are not sure now who bears the honors. This is a contentious issue. Can the court guide us? But that doesn't mean that the application is incompetent. You are simply requiring, you want to approach the matter from an informed position as the state. What do you have to do to discharge an honors if it is on you?
My Lord, it is the state's submission that the state says the application is incompetent where there was a previous application which was made to then give the state the honors to prove compelling reasons. We are saying in such application where there is a judgment which is extant, the state has no honors. So that application, if it were to be made, it is incompetent. But what is incompetent is an application where the applicant has the honors to prove that there are certain changes because in terms of section 116C, and therefore the state from the beginning it won't have the honors. It can only respond. Okay. So under the circumstances, the state insists that the application, in view of what has gone on before, the application is incompetent. To compare, to say the application must be made on the understanding that it is the state which has to prove, which has got the honors.
I see.
Yes.
Oh, okay.
That is the context in which it is saying so.
This is it. Okay. For every objection, there is a remedy that is sought. What is the remedy that you seek?
An application which gives the state the honors again. It is the state that that application is not competent and therefore must be removed off the roll because that issue was determined. No, it cannot be determined again.
In terms of what law? I'm simply trying to say that we are applying the law here.
Yes.
The applicants have wrongly attributed. I'm not ruling. I'm saying that is what you understand them to be doing. They are wrongly attributing the honors to the state, isn't it?
Yes. And
so what remedy, having objected, if I uphold your objection, what then should I do?
The application has to be removed off the roll and they have to start again. Make a proper application in view of what
something that is removed from the roll does not die. It remains alive. In other words, they can't start a fresh application when a matter has been removed from. That matter remains pending.
They will decide.
No. I'm saying when you remove a matter from the roll, remember we removed the bail application from the roll by the accused persons. Did it die? Was it a dismissal? That matter remained on the roll, and we said we are removing it on the roll until such time that it can be heard properly. So when we remove a matter from the roll, in terms of our law, that matter remains pending before the judge. I think that is the law, unless I'm misunderstanding something. It's different from striking off. When something is incompetent, then we strike it off. We say it's a nullity. Is that what you want me to do?
The state will then apply for the amendment of its order, of its prayer, that the case be struck off
As a nullity.
as a nullity.
Of course, it's an application that you are making. They will respond to it as well. You are amending your draft order, isn't it?
Yes.
Proceed. If you have any other submissions.
Yes. In view of the foregoing, my lord, it is the state's position that what my learned colleague intends to take the court through is scandalous, because if IOs were to be called again, the whole process to be repeated, there will be two records on the same issue. That clear.
Why are you concerned about that? If you don't want to call the IO, you just don't. No, if the accused persons are not conducting the state case, if they suggest that you must call the IO, that is not an order of court. You simply don't comply. You simply don't do it.
Yes, I don't think we'll get to that. Because
because I don't have to rule on that. You are not obliged by what to comply or follow what they say. If you think it's wrong for them to require you to call the IO, you simply say we are not doing it because we don't feel that that is the way we should proceed. You are conducting the state case.
yes.
Whatever they say, you are allowed to disregard it. So the court does not really require to make an order, because you are not under any obligation to follow what they say you should do.
All that the state wishes to say is that this court cannot disregard an extant judgment of the lower court,
Thank you.
and
No,
then decide to embark on an application of its own, which dovetails the process that went through in the lower court.
Yes.
Yes. And for that reason, the only, in terms of section 116C2, the only application that they can only make according to the state is an application where new circumstances have arisen, which were not before the magistrate court when the first application was made.
Thank you.
If all these circumstances were placed before the magistrate, they cannot be placed before this court again. Only new circumstances. And for that reason, in view of the fact that the applicants are insisting that this is an application which totally disregards the proceedings before the magistrate's court, and this court has to start afresh as if they are coming from the police cells, then because of that insistence in the application, it is prayed that the application be struck off, because that cannot happen.
I'm with you.
Yes.
Is there anything else?
That is all, my lord.
Yes. Now, Mr. Tritoro, you can then respond. Maybe if you think, for the purposes of continuity of your argument, you want to repeat what you have already said so that your argument flows, it's up to you.
Thank you very much, my lord. I'll start by saying the state is putting words into the applicant's application. The application is very clear what it is. I'll refer this on report to page 2 and page 3.
So the state is putting words into the applicant's
Mouth.
not mouth.
on page number 2 of the first accused person's application, he mentions what it is.
This is This is Mr. Mpofu.
Yes.
Okay. Wait a second.
It says application for bail pending trial in terms of Rule 90 of the High Court Rules 2021 as read with Section 117A of the Criminal Procedure and Evidence Act. He identifies the provision in terms of which the application is made.
Just out of interest, why is he subordinating a statute to a regulation? It's just out of interest.
No,
I thought an act of parliament is superior to regulations.
No, my lord, if the reason is when you read the act itself, it then says rules may be made
Precisely.
to then make procedures.
So it is the mother.
Yes.
It must be mentioned first.
Oh, well, my lord, maybe it's an issue of the chicken and egg.
No. That, in fact, that is the position. Not that it will change anything,
Indeed.
but it always makes us realize that regulations are subordinate to the Act of Parliament. Something like that. You are constantly reminded of that, because those rules are made in terms of some other enabling act. But look, it won't change much. That's why I said out of interest. Yeah. But there are circumstances when it may become important.
Indeed, my lord. Maybe the applicant wanted to be specific in terms of which rule first. So it's made in terms of Rule 90, and it's made in terms of Section 117A. And that cannot be said to be incompetent. In paragraph number 1 of the bail statement itself, the applicant says this is an application for bail pending trial made by the applicant.
In paragraph?
In paragraph number 1.
Okay.
He says it's an application for bail pending trial. So it's him who's making a distinction of a fresh application and an application based on changed circumstances. The applicant himself is not distinguishing, he's simply saying this is a bail application that is made in terms of Section 117A. So now, to indicate that the state's submission does not take us anywhere, because the state is saying applicant ought to have said.
Also, your client never used the word fresh.
Yes.
No way.
No, in the application, in the bail statement, it's him who's choosing words to put into the mouth of the applicant.
Oh yes. I'm reading paragraph 17 there.
Yes, ma'am.
You are right. It is the registrar who said file a fresh application, and then the accused person filed a bail application. It's very clear there. It's very clear.
Indeed, my lord. I sense also that we are not convicted of making the law and naming applications the way we want.
I had been persuaded to find that you also legislated. But anyway, look, these are issues. I see that is your response to what the state has said. And sure enough, I can see in paragraph 17 you said, hence the current application for bail. You never said, hence this fresh application for bail.
Indeed.
That is very clear to me.
Indeed, ma'am.
Yes, thank you.
So the state is going further and saying we ought to have indicated that this is an application in terms of Section 116, subsection C. So one needs to go to Section 116, my lord, to see that even Section 116 says that an application that is even made in terms of 116 should be made in terms of Section 117. My Lord, I'll refer this whole report to the relevant provision of section 116C2.
Wait there. One 117.
116, my Lord. It starts off, my Lord, by saying that subject to this section and sections 32 and 34, a person may, upon an application made in terms of section 117A, be admitted to bail or have his conditions of bail altered. It then gives circumstances.
That section?
116, my Lord.
Subsection?
The 116 itself, my Lord.
Oh, wait.
Before you get to see it,
To see,
it states what kind of an application must be made.
Okay, wait. Okay, the first line.
The first sentence, my Lord. It says, subject to this section, in section 32, section 34, a person may, upon an application made in terms of section 117A, be admitted to bail or have his bail conditions.
So you are saying all applications, whether
Yeah.
it's for alteration, whether it's the first application to be made, they are all made in terms of section 117A.
Yes, my Lord. Because you then get that all those other provisions, A, B, and C, which is relating to, is following that sentence. That is when you are reading section 116, it then says you can be admitted to bail or have your conditions altered.
Or these others are paragraphs
They
of
are
that.
paragraphs, precisely. So 116 cannot be a substantive clause on its own. One person cannot come to court and say, I'm applying for bail in terms of section 116. You cannot be admitted to bail in terms of section 116. You can only be admitted to bail in terms of section 117A. This is why I say my learned colleague must really be careful to say it's not competent because it's a fresh bail application or it's not an application of change circumstance, because we have never drawn that distinction. It is them that is drawing a distinction which they are making for themselves, mischaracterizing the applicant's matter, and then giving us a route that the applicants are not taking. When the applicants are clearly saying we are here in terms of section 117A. So if his argument is that the application is not competent because it's made in terms of section 117A instead of it having been made in terms of section 116C, that position, my Lord, would then not be a preliminary point. It is an argument on merits, on whether or not the order must be granted. To say you have come via a wrong procedure. My learned colleague then goes on to say that which it is referring to as a point in limine must be determined first because we must know who is the owners. My Lord, the defense that I do not have an honors or I've discharged my honors already is a defense on the merits. It's not a preliminary point. If I understand my colleague's argument correctly, he is saying we went to the magistrate's court. We discharged our honors of showing that there are compelling reasons to deny the applicant bail. The magistrate court has already determined that matter, and that order of the magistrate court is extant, and therefore there is no need for me to call an IO or to discharge that honors. It's an argument which he has to say in a response, to say the state has already discharged the honors, and we feel we are okay with it, then sit down. Then the court will determine if he has discharged the honors or not, or whether or not he has honors. It is for the court to determine who amongst us has honors to prove what, and see if we have managed to succumb that threshold of the honors, my lord. It can never be a preliminary point. In other words, my lord, we are both clear on issues of honors in our separate understandings. We are saying the honors is with the state to prove that there are compelling reasons. They are saying the honors is with you to prove that there are changed circumstances. We must make our arguments. The court must determine in its determination of the merits of the matter to say the honors in this matter lies with the applicant or lies with the state, or whether or not the applicant has discharged its honors, or whether
Is there
or
any
not
difference between burden and honors?
In some instances there could be distinctions, my lord, but generally,
in some instances they could be different, isn't it?
yes.
I'm just trying to understand, I hear you quite clearly, both of you.
Yes, my lord.
But I want to be sure that you are probably that you are not arguing at cross purposes.
Yes, my lord.
It's just like a defense.
Yes,
When an accused person says, I have a defense to this charge,
yes,
he has to state it, isn't it?
yes, my lord.
He has the burden to lay a basis for whatever defense.
Yes,
Then, once he has successfully done that,
yes, my lord.
the onus then shifts to the state to displace that defense.
Yes, my lord.
So, is there no possibility of mixing terms here? That if you are alleging new facts, then you must say them, and you have to tell the court what the new facts are, and make the court see them, isn't it? It's naturally the responsibility of the person who is making that averment, isn't it? It goes without saying. Okay, let us migrate a bit from this. Let's say somebody believes a situation arises which may necessitate the accused person to make a further application, which was not there before. Whatever situation it is it not? It is the accused person who must say what it is,
Yes.
and at the very least demonstrate to the court that such a situation has arisen. Is that honest?
No, my lord. If I understand the situation that you are describing in line with what the state is saying, in other words, the state is saying, is pleading res judicata. The state is saying the magistrate's court has determined this matter.
Okay. But I just wanted to be sure that I understand that the state was insisting on honors.
Yes.
But does the accused person not have some responsibility to, at the very least,
Yes.
if it is a further application in terms of subsection C, is it paragraph? Yeah, paragraph C of section 116, to at least place the facts before the court.
Indeed, my lord.
What is that? Is that a burden or is that an honors?
It's a burden, my lord.
It's a burden.
Whilst they are accused persons, they are also applicants in this matter.
Yes.
They have an application that they've placed.
They must
before.
motivate it.
They must motivate that application. And in motivating it, they may say, oh, look, all we need to do is to mention
So
one,
maybe
two, three.
that is what the state is talking about. That if it matters now to know whether this is the application first of its kind, or it is an application that is to be considered as a further application, in which case the accused persons must motivate it and they naturally begin.
Yes, ma'am, that is what the state is intending to do, but it cannot do so. It cannot seek advice from the court to say, do we have honors or not? It cannot do that, madam. We have to motivate our application. They oppose it. If they feel they discharged their honors, they're entitled to actually sit down and say, we discharged our honors in the magistrate's court.
Oh, okay.
It's over. The application must be dismissed.
So there's no
That is their
requirement for the
defense.
court to rule on who has the honors. You are saying we just proceed. You do what you have to do in
Yes.
the interest of your clients.
Yes.
The state does what it does in the interests of the state,
Yes.
and then you can then argue these issues arising from what has been placed before the court.
Yes. If we do what we have to do to assist our client's cause, my lord, and the state does what it does, it may then come out from those arguments that there is now an issue of law to determine who bears honors. But it can only arise in the arguments of the merits.
Okay, it can be a
And
preliminary
It
issue.
can be a preliminary issue. And it then therefore goes to say when the court then makes a determination, may have to first of all determine that aspect. But for you to call it a preliminary point would be really to misguide the son of the court, because it's not a preliminary point. In other words, what the state is saying is if the state, if the court rules that they have no honors and the applicants have honors, then the matter must be stricken off the roll. That is not correct, my lord. If the court determines that the applicants have an honors, the court must then determine whether or not they discharged that honors or not, and then make a necessary determination. In other words, a determination of who bears the honors cannot be a basis to have a matter stricken off the roll. So it is their own point in limine which is misplaced.
Thank you.
My lord, then my learned colleague also stated that it would be scandalous for the court to persist with the application as it is, because then they will be forced to put an IO on this.
Don't worry, I didn't feel threatened. Let's deal with the actual merits.
Indeed. Thank you very much, my lord. But the point that I wanted to make from that, my lord, that it is up to the state to litigate the way it wishes. It's up to them to call the IO. It's up to them to place facts that they wish to place before this honorable court. But they cannot say that they would be forced to pursue the application in a certain matter because the court is proceeding to hear the application. It is not like that, my lord. Then, my lord, the other point that I wanted to make, I'm not too sure whether or not my learned colleague has, in answering the court, in fact motivated his objection or not, because it relates to the merits of that objection itself, my lord.
I think he said he has done so.
Thank you very much, my lord. My lord, one then also needs to then determine that what he is relating to, whether or not it has already been determined by this court or not. And it is my submission, my lord, that that aspect is now res judicata. The court
Which aspect?
the aspect of what these proceedings can be, whether or not he wants to call them fresh or not.
No, I was just probing him. I haven't ruled in the matter. I was just complaining that there's always a tendency, the profession to name, to give these applications names that are not in the statute. I think I wrote that judgment in the context of application for suspension of reporting conditions. I don't find it anyway. It's called an application of alteration of bail reconnaissance. So when you start naming it like that, then we start, interpreting what is suspension of bail conditions and so on, when you don't find it in the statute. The statute talks about alteration. So I'm simply trying to discourage us as a profession from, particularly where the statute is the main source of the law. Let's just call it by the name in the statute. We can then always find help in case law in interpreting that statute. But the interpretation does not substitute the wording of the statute.
Indeed, my Lord.
That's my understanding.
Indeed, my Lord. Yeah. The submission that I'll make, my Lord, is that even if you wanted to make that distinction, it would be clear, and I would submit that His Lordship is correct to say that it is fresh. It is a fresh application. Give it from whichever angle you view it from, because it is an application that has to be determined by this court afresh. And that is so also when one bears in mind this Honorable Court's decision in the matter of Moses Mpofu and Mike Chimombe versus the state, HH 409 of 24, where His Lordship on page number 3, it's this to say, it indicates that it is clear from subsection 1 of section 66 of the Criminal Procedure and Evidence Act that in general, the indictment of a person to be tried in the High Court is a whole new process. This is what His Lordship said on page number 3 on paragraph number 2. And on page number 4, first paragraph, His Lordship had this to say on second sentence. If the person is already in custody, the peremptory provisions of section 66 subsection 2 require the magistrate to issue a warrant for the further detention of the person in prison pending his or her trial before the High Court for the offense for which he or she has been committed. The underlying is for emphasis. The indicted person is therefore further detained not because he or she was denied bail, but is further detained in terms of a warrant. A person who is coming from police custody, whether due to arrest, with or without a warrant for extradition, is, in my view, upon indictment, further detained until he or she appears before the trial court in terms of the warrant issued by the magistrate in terms of section 66(2) of the Criminal Procedure and Evidence Act. And then on the third paragraph, His Lordship mentions that in terms of section 137 of the Criminal Procedure and Evidence Act, the status of the applicants who were on remand in the magistrate's court changed when they were indicted. They ceased to be on remand. Their matter became pending in the High Court and are now held in terms of a warrant issued by the magistrate court upon their indictment. Then, in concluding that matter in the last paragraph, which is really the ratio, this Honorable Court referred to, with approval, to the case of Chinanga versus State, Chinanga, yes, versus State, HH 429 of 2015, per Matonzi J as he then was, where a trial which was intended to begin had then been postponed, and the court then admitted to the accused person to bail as a, I would call it fresh, to borrow from my learned colleagues' diction, in terms of a fresh application. So the applicants are therefore not being denied the right to seek bail pending trial, but are refusing to utilize a statutory process that gives them access to trial, to the trial court and seek early relief. They will get the relief, if merited, when they appear before the trial judge on the 1st of October 2024 or earlier, if they utilize the provisions of Section 160, subsection 1 of the CP and EA, whereupon the applicants may, if they do not make an oral application, an oral bail application, re-enroll this matter. So this one, the court was already alive to the fact that the accused persons can make a bail application. And this is the bail application that the accused persons have made. And then lastly, the point that I'll make, my lord, is that even the provision that my learned colleague relates to, Section 116C itself, my lord, cannot be interpreted in the manner that he interprets it, because it states that an accused person can be admitted to bail in terms of Section 117 if he or she is a person whose case is adjourned in terms of Section 55(1)(2) of the Magistrates Court Act, or in respect of whom an order has been made in terms of Section 3514 by a judge or by a magistrate within whose area of jurisdiction he or she is in custody, provided that in subsection, in item 2, which my learned colleague then refers to, where an application in terms of Section 117A is determined by a judge or a magistrate, a further application in terms of Section 117A may only be made whether to the judge or magistrate who has determined the previous application, or to any other judge or magistrate if such application is based on facts which were not placed before the judge or magistrate who determined the previous application and which have arisen or been discovered after the determination. So in other words, the provision that my learned colleague is relating to envisages that any other application for bail that is made subsequent can only be made to the person who had the matter. In other words, what my learned colleague is implying is that if the accused person wants to make a bail application, they must go back to the magistrate's court.
Oh, is that what you said?
That's what the section says. Either you go to the magistrate's court and make a bail application, or if you are relying on what is then saying the new circumstances, which is saying the changed circumstance, this is where you can then go to another magistrate. But it does not allow for the mixing of the two methods. So in other words, whichever application he says, whether as a fresh bail application or as a changed circumstance application, in both scenarios in terms of this section, it must be made to the either to a different magistrate if it is based on new circumstances, or to that very same magistrate if it's a fresh bail application. But this court has already determined that once an indictment has been issued, those accused persons are no longer appearing before the magistrate's court. They are now appearing before the High Court. So, because of that, my lord, it is clear that the accused persons, if we were to make a distinction, they are making this application as an initial bail application pending trial. Ever since they've applied, it's not
or you are saying that the accused persons are making this as what?
As parties who have appeared further to a warrant that was issued by the magistrate's court, not as people who were denied.
And their application, you are simply saying the previous decision by the magistrate
is not
is irrelevant.
Is irrelevant. Not entirely irrelevant, my lord, but I'm saying in the sense that in respect of the fact that my learned colleague says you have to do an application for changed circumstances, it's irrelevant to that objection.
I mean, to what extent is it relevant, and to what extent is it? I'm not clear. It's either it's relevant or it's irrelevant. It's either the court is entitled to take that into account, or it is not.
It's irrelevant, my lord. It's irrelevant, my lord. That is the submission that I will make. And then the last submission, also, my lord, that I will make is that there are a plethora of case law, my lord, which indicate that bail applications by their very nature are sui generis. They cannot be confined into a particular sleeve or particular slate, as the state would want to say, oh, we can raise a point in limine and then it can be stricken off from the roll because, or it can be struck off from the roll on the basis of that. In bail applications, the court is at large, my lord. There are plethora of case laws where the court can even have regard to facts that have not been placed before the court in bail applications. So the court is largely at large in bail applications because this connotes and relates to constitutional provision, to a right to liberty. So the approach of the state, my lord, is to be over-technical and not to think about the constitutional right to liberty that the accused persons have. The state is only making this point in a bid, in my respectful view, my lord, to stop the applicants from making an application for their bail, my lord, which they are entitled to. Those would be my submissions, my lord, unless if you wish me to clarify another one.
No?
Thank you,
My lord, I would be helpful to the court. I'm going to be very brief. I will abide by the submissions that have been made by my learned friend for the first accused. But there are few points, very few points that I wish to add, just simply to help clarify the issues. First point I wish to make and place before the court is that the duty of the court is to determine an application that has been placed before it. So all what is happening is that the court is being asked to determine an application, and that application is made in terms of Section 117A, subsection 1 of the Criminal Procedure and Evidence Act. I respectfully submit that from the exchange that has happened, it's now clear that such an application is properly before the court, that an application for bail can only be made in terms of that section, 117A, subsection 1. This is the point that my learned friend, Mr. Judicial, was making when he was closing, when he's indicating that Section 116 does not deal with applications for bail. It deals with the powers of the judges and magistrates to grant bail. It's very clear, it says power to grant bail. Then indicates some of the issues to be taken into account. So in the proviso is that when a judge or a magistrate were to be faced with an application where a previous application had been made, then they have to consider whether or not enough facts have been placed. But otherwise, the application is made in terms of Section 117A. That is first point. Then the second point, my lord, related to the point which is a point of principle, the distinction that was raised by the court, honors, burden, and so on. I thought I should just fairly help the court in that regard, that and the honors is always on the person who is making an application. The person who is coming to court has an onus. That it simply means the responsibility to place before the court that which will make you to succeed. That's what an onus is. You cannot just go to court and sit. You go to court with a responsibility, with a duty to place before the court that which, if not answered against, you would succeed. That is generally the understanding of an onus. And then the issue of a burden, in this case, it is the act that uses the word burden. The word onus is not in the Criminal Procedure and Evidence Act. it is actually the word burden, which is in section 115C, where the issue that arises of compelling reasons for denying bail, then the Act is very clear that it places the burden on the state in respect of some offences, and then the burden on the accused person in respect of other offences. That's section 115. I was reading it as the exchanges were taking place, and I found that the lawmaker was continuously using the word burden, and that burden to show compelling reasons will always lie on the state. There's nowhere ever it will go except where it is in third schedule offences. And I think so. We as applicants under section 117A, we have an onus to place before the court those issues that will make us succeed. So we've done that, and the applications are very clear. Like what Mr. Judicial said, we never use these terms that Mr. Mabawadi was imputing to us. Our application in terms of section 117A, and we've placed the facts. What we've said, not now, but just to deal with the objection, is to say that we believe there are no compelling reasons, and we have grounds upon which bail must be granted. And depending on how the argument goes, when we go to the merits, we'll be able to demonstrate that there is merit in our applications, whichever way one wants to look at for the applications. Then finally, my Lord, because I just want to just write so that I don't get to waste the time of the court. In fairness to the state, the only issue we might put before the court, which, depending on how the court characterizes it, is what section 116 says, the proviso. It says that when application in terms of section 117A is determined by a judge or a magistrate, a further application in terms of that may only be made. My understanding of Mr. Mabawadi's long argument is very short. He maybe wanted to argue that this is a further application in terms of section 117A as contemplated by the Act, that the applicants have not characterized it as such. He wants to give it a character and then says that. That is where that point is not a point in limine. This is the point where we make it. That point goes to the merits of the nature of this application. And let the applicants make their point. And when the applicants make their point, they will argue, and we are putting it up front, that this is not a further application as contemplated in section 116C, the proviso. This is the only point I will sit if my Lord doesn't want to question me. I wanted to make that point. That is the only point where we can go to. If his argument is that it is not a further application, that's not a point in limine. He will say that. Because the danger that the state has is this, my Lord, and we want to be open with them. We want our clients to be having a fair hearing, and so we do not want these small games where they might want to raise issues. We want to be open with them. If they gamble and take the view that this is a further application, and they do not do what would be done, which is to show compelling reasons, and they lose on that point, then our clients will be entitled to pay. No one would ever oppose. That's the point we want to make, because we are going to be arguing on the merits that in terms of the law, once a person has been indicted, any application they make post their indictment is not, when the act is read properly, is not what the act calls a further application. It is a new application, and our learned friend did give an answer. We whispered to him that what the magistrate have done is irrelevant, totally irrelevant. I would want to get other words, totally irrelevant. If their issues when they deny you bail, they are denying you bail pending indictment. If the person is not going to appear in the magistrate court, that remand process where bail is denied, it is just denied pending indictment. And that is what ought now to be put in the jurisprudence. This is pending indictment. When indictment comes, everything is taken out, and that is what, my Lord, you said in that judgment. I want to complain that my learned friend has not bothered to address you on your judgment. This judgment in the case of the Chimombe application, we actually attached it, and we do say in terms of the our preamble, we say that this is an application in terms of section 117A1, as read with section 66(1) and 66(2) of the same Criminal Procedure and Evidence Act, and as further read with the judgment of this Honorable Court in Moses Mpofu and Mike Chimombe, these are the state HH. We said that, and then we attached that judgment. And we have argued in the application that our view is that this is not a further application. And I've said it to him, even outside and here, even when we were waiting for the court, I've kept on saying to him, our view is that it's not a further application. He might have to put his house in order. And so if there's going to be a ruling, it has to be a ruling in the course that is on the merits. If they don't do it now and prepare themselves properly, then we have that is a problem we'll face. And these were my submissions, my Lord. In fact, when we go to the merits, you will find that the application we have placed before you, both applicants, it is such that in the alternative, even if one wants to call it a further application, there is enough material on the application to support an application on further, if one calls it a further application. So it is for the state, I hope he responds, it is for the state to be sure that we are saying it's not a further application under section 116. So that is all.
You have been very clear and lucid in your explanation. What I want to understand from you is the court precluded from taking into account the proceedings in the lower court, particularly with regards to the evidence that has already been laid? Do we need the investigating officer to come and tell us what he has already placed on record, which is part of the record that I have?
Thank you, my Lord. When we get to the merits of the matter, we will argue that the court is precluded from doing so, for the sole reason that these are proceedings which have no relationship with the proceedings pending indictment. In fact, there are two processes in our criminal system. You are arrested. The magistrates are given this responsibility, and it should not be exaggerated.
So you are saying the court is precluded from taking into account
proceedings before the magistrates
in the magistrate court.
Yes, and it is precluded by operation of law.
Maybe I hope I've made myself clear. I'm not talking about being bound, because I know you are very clear about that, but about peeping into that record and seeing what were the facts placed before the court. Am I precluded from doing that?
My Lord,
that record is already before me.
Yes, the record is before you in purpose of the trial. It's not the record before you for purpose of this application. We notice that the provisions that say that the record of the bail are before it is when the trial takes place, those proceedings will be before you. But when you are considering a bail application of this nature, which is a bail application made pursuant section 117A after indictment, you must look at it on the facts as they will be brought, because the burden to demonstrate compelling reasons will be coming. If the state decides that as part of discharging its burden, it wants to bring on board the proceedings in the magistrate court, so be it. But the court cannot on its own look at it. That is our submission. In fact, that is the submission we make, which is consistent with the judgment that we've made, which we are saying it with all due respect, my Lord. It's a very correct judgment. That judgment is very correct. Not only is it very correct, even the observation that my learned friend, Ms. Mabaudi, was not wanting to listen, that there can only be one application under 117A. It took him a lot of time to appreciate that very clear point. And this is where, so we are saying it's irrelevant, totally irrelevant. My Lord, let's say after conviction, for example, we know the bail proceedings in the magistrate court, they come to an end, or the proceedings in the magistrate court, they have a life. Once you have been indicted, that is out. Because the magistrate court is playing this gatekeeping. It has a unique responsibility. But it cannot determine matters when a matter is now, when a person is indicted, is appearing before this court. Surely, it is an application before this court, which now knows all these changes as a now a matter before the court. We would not think that those proceedings must be taken into account, the previous proceedings. We appreciate it's a question of law, and it's for the first time that these issues are addressed. So our prayer, my Lord, would then be, perhaps just to finish, that the court must find that there is no valid objection, that we must go into the application for bail. And the state has all the world to oppose it in the manner that it will deem appropriate.
Thank you. Mr. Mabaudi?
Thank you very much. I would like to start with observation which was made by Professor Mabaudi that bail.
Call him Mr. Maduku because as
Mr.
soon as you
Maduku.
call him the professor, we'll all be afraid.
I thought that was his intention to be.
No,
failed.
he's here as Mr. Maduku. Well, you know, we will then want him a professor at the university. Our
So
professor.
comforted, my lord. Mr. Maduk's last observation that bail rulings are only binding on the lower courts and they are not binding on the High Court. I think that cannot be the position at law. What he has just said is that the decision of the lower court denying the applicant's bail is not binding on this court. It was something that happened there. It lost relevance when the matter was referred to.
I think what he's saying is that the denial of bail seems to have lost its relevance when the accused persons were indicted, because then they became detained not because of that decision by the magistrate, but because they were now being held in terms of a warrant. So he's saying it then died.
My lord, the state has spoken in its submission about this warrant. In the High Court judgment number HA 409 was only speaking to the period between indictment and appearance before the trial judge. It did not talk about what would happen thereafter. The essence of the judgment was that the applicants were not supposed to make applications after a warrant has been issued until they have appeared before the trial judge. The effect of the warrant was to the effect that it would detain them until they appear before the trial judge. I think this is the context in which that judgment was made. Applicants had made application after they'd been indicted, but before they had appeared before the trial judge. The question which was before the court was whether the applicants could make an application in view of the warrant that had been issued. So the warrant in terms of section 66 subsection 2 of the CPNE Act was the crux of the matter. That was the issue which was being dealt in that judgment. I don't think there is any part.
I'm with you in terms of what you are saying. I hear the submission. I will have to rule on it. You want to object?
No, I wanted to assist the court, my lord, that the court was very clear. It indicated that when the applicants then appear for trial, they may make a bail application.
Well, obviously, I will read that judgment again. I read it when it was raised. He's interpreting it for me. Parliament is not allowed to interpret its own laws. We do. So you are entitled to interpret it, although I made that judgment.
Indeed, the state is not saying the applicants are not supposed to make an application. That is not what it is saying. They are entitled to make an application at any stage. Now, but it is the nature of the application. The second accused person, Mike Chimombe, in paragraph 28, he is speaking to section 117, subsection 3 and 4. Speaking to the considerations which are taken into account when an accused person is making a first application before the court. whether it's likely to abscond, to interfere with the evidence, to commit further offences, etc., etc. The first accused person is talking about that. What it is very clear from the application, written application, that what they are talking about, it is about an application which is made when an accused person wants to make his first application. That is what they are saying. But the state has cited judgments that in terms of section 116, subsection...
so if the accused, assuming I uphold your objection, or perhaps I agree with you, without necessarily upholding that we are concerned with new circumstances, are these new circumstances considered in isolation?
Oh, this is what the state was saying. That what the accused person should have identified the reason why they were denied bail in the first place. So those decisions, they were never replaced by the
decision, the findings made by the trial magistrate.
The warrant, rather. The warrant did not replace those reasons why they were denied bail, that they were likely to abscond and so forth and so on.
No, you have made your point.
Yes.
You have really made your point. What I want to understand is, sometimes it's clearer when you give an example. If for example, at the time of a circumstance did not exist at the time that the first application was made, and then it is shown that it's a new development, or it's a new fact, or it's a changed circumstance, whichever word you want to use there. Does the existence of that fact, is it the only consideration by the court, or it is then considered in conjunction with other factors?
There's a judgment by Justice Cheddar that when deciding a new factor, which was not before the trial court magistrate or judge, that new factor should not interfere with the findings in respect...
Already made.
Yes, which were already made. That judgment is very clear on that. So the court is not being called upon to review the decision of the court call by the back door.
If somebody did not own a house at the time that they made an application, and somebody, or they managed to acquire a house, and they say, well, we can perhaps allay your fears by offering that property. That's a new factor, isn't it? They didn't have it in the first place.
Yes.
Now they have it, although the law is not for the rich, but it's a relevant fact,
Yes.
isn't it?
Yes.
Does that fact entitle him to bail, or it is considered with other circumstances?
No, the state has always said that the main fact that one has said there is
a movable property.
Movable
or
property,
a new
or
fact.
any new fact. It does not preclude the state from deciding whether that new fact, if there is any compelling reason why that new fact should not entail in the applicant being given bail. There may be a new fact, but they may also be compelling reasons in respect of the new fact. So
Okay,
it does
I
not
understand.
automatically...
I understand you. You are saying that the new fact may not necessarily result in a different outcome.
Yes.
Okay, that's fine.
Not at all. It might not say automatically there's a new fact. It has to be considered. Yes. So I think the precedent that my dear colleague is seeking to establish, that a magistrate's court decision will come to an end. So it means if it comes to an end, it means the findings which were made, the compelling reasons, are no longer there.
That's exactly what they're saying.
This is what they're saying. But
No, they're not. They're saying they are no longer there. Irrelevant just means that the court does not pay attention to them
Yes. Which
Whatever
means-
the magistrate said, whatever the magistrate found, I shouldn't pay attention to that.
So
That's what they are saying.
So it means that based on the warrant, which will expire on the applicant's appearance before the court, trial judge, it means that there is nothing precluding them from just walking away because they are no longer compelling reasons. Because the held compelling reasons, they just evaporated.
Are we not? I know they say putting the cat before the horse. Is that what they say? Imagine a cat drawing oxen, because I don't know the best way of putting it. When you say putting the cat before the horse, it doesn't come out clearly. But imagine an ox-driven cat moving in the opposite direction, it drawing. Are we not really discussing what you should be telling me in winding up your cases? Whether I should be taking this into account, whether I should be doing that. How, on what basis should I be making those facts? But anyway, I was just thinking, I don't remember the citation. Have you read the judgment by Justice Deme in the Scala matter? Job Scala matter. I think he had made 8 bail applications. And the judge was ruling on the 8th bail application. But I'm thinking that application was still made and decided on. Where he said, look, if the reason you were denied bail is that you would interfere, or is that you have previously breached your bail conditions.
Yes.
Even if you make 20 applications, that does not affect that position, isn't it?
Yes.
But at least Scala was able to make the applications. The court simply denied to be swayed by because it said we have already decided on these facts. We have already decided that you have a tendency of breaching your bail conditions. That's why we've been, and that has not changed. You are still the same person who has that tendency, and that remains. Whether you have spent 3 months in prison, whether you have spent 12 months, you remain the same person who breached the conditions. So we will not. I'm simply trying to say that the issue of whether or not this application should be made was not, or maybe you are raising this for the first time and you want it to be determined for the first time. That such a court must always, before going into a bail application, determine whether it's a first application or it's a third application. You are saying that is the precedent you want to be determined.
I think maybe starting from what they are saying, from what Mr. Maduku said, that is the proceedings in the lower court, they are irrelevant. So what this court has to do, it has to start afresh. As if the accused person...
But why should I rule on that?
4242.
Why should I rule on how the parties should convince me?
Now, the issue that the state is raising is, if the state's contention is upheld that the lower court's ruling is still extant, it means that the applicants have to establish that they are...
My question to you is, why should... That's why I'm talking about the cart pulling oxen. Why should I, as a court, be part of that process of advising the litigants who are before me how to make out their cases? The applicants want a judgment. They have their own cause of action. It's up to them to establish it. Why should I be telling them what to do? The state wants a judgment in its favor, isn't it? If I dismiss the application, it's a judgment in favor of the state, isn't it? Why should I tell you how to succeed? In terms of, you understand what I'm saying? You want me to rule on who has this and that burden. You want me to rule on who is this or that illness. Why should I be part of that? I'm not representing the applicants. I'm not representing the state. Do whatever you think is why should I be ruling on that?
My Lord, the procedure is very important. This honorable court cannot be taken on a perilous path, because the court will see at the end.
Because if I tell you, if I say what the procedure is, I there are likely to be two problems arising from that. I have joined your camp. And secondly, I could be wrong in terms of what the procedure is. I have an opinion, but it's not necessarily, correct. But the bottom line is that I don't want to come into your camp and tell you what the procedure should be. It's there. Find it. Find it.
But the question is, I think what the question before the
If
court,
it was a matter that is not provided for, then you would ask me, because there are always areas which are grey, where the court then has to direct the parties. If you remember, I'm sure, I don't remember what it was in the trial, when we agreed that there is a grey area and I had to come in and say, this is the way we are going to proceed. I'm entitled to make those rules where there is no specific rule applying. But anyway, is there anything else that you wish to say on the law?
my learned colleague for the first applicant submitted that the issues being brought to this court by the state as a point in the meaning, it is not a point in the meaning. The state, it is the state's submission, my lord, that this is not, the issue being brought to before this court is not a point on the merits. A point on the merits in this particular case is a point that will entail in the decision to either grant the applicant's bail or not. Those are relevant tribal issues. Relevant tribal issues to the bail application. But this issue is, which has been brought by the state, is that whether the procedure that has been taken, where they are citing section 117, subsection 3 and 4, where the state has to now start by starting out disregarding the magistrate's proceeding and start calling evidence. The state is saying that is not the procedure.
They should have made this in terms of which section?
If they asked me, I would have maybe suggested section 117A as read with section 116C2, because the bail application in terms of section 117, but in particular on changed circumstances, which were not before the court. This is the way.
So they must implicate. They must read the two sections together.
Yes,
That is what
the main section is 117, but as read, which is indicating that it is on changed circumstances, on issues which were not before the court, which denied them bail. That should have been the section, not to just invite this court that disregard what is in the magistrate's court. It fell by the wayside. Let's start afresh as if the accused persons have come on Form 242, which is what they are saying both in the application, because they are talking about section 117, subsection 3 and 4. Maybe they want this honorable court to start by saying how were they treated at the police. That is where they want to start. I don't know where they really want to start.
You already. That's why I said, you want me to decide on a stage that we have not reached. We have not reached the stage where the parties are placing evidence before me. Have we?
But yes. But however, my lord, according to what they are saying, on this application, the state will then start saying the state is going to prove its case first. It's going to call the IO and other evidence to prove its case. But we are saying, the state is saying that position cannot happen. It is really, it cannot be ignored. It should be which factors have arisen since the time they were denied bail. Which new factors would would want this court to consider whether they are.
So if the
propaganda
accused
for bail.
persons begin, the applicants, if they begin, is the state precluded from calling evidence in opposing the application?
If they begin, it
Yes.
means they are talking in terms of section based on changed circumstances. Because that is where they have to start by giving a basis of what is arisen since the time they were denied bail and now. That which may persuade the court to grant them bail. Because otherwise, it is always the state that has to begin, because it is the onus to prove that they are.
And if it doesn't begin, it won't be able to discharge that onus.
If they cannot begin, no, if they are to begin, it means they are already acknowledging that they have an onus to establish something.
Okay.
It's no longer a fresh application because they are now having to start themselves, and the state has to rebut and then prove that there are compelling reasons.
Let's look at section 117 together, Mr. Mabaudi. 117A. 117.2a, 2b. What happens at the hearing, at a bail hearing?
117, 2B.
Yes. No, I'm wrong. It's 4b, sorry.
4B. 117.
What happens at the bail application?
In considering
In bail proceedings. Am I looking at a wrong subsection 4b?
capital letter A.
Yes, capital letter A. Yes. Sorry about that.
4B. Okay. That in bail proceedings, the court may, subject to subsection 5, receive evidence on oath, including hearsay. Yes.
Proceed.
Affidavits, written reports, which may be tendered by the prosecutor, the accused, or his or legal practitioners, written testimonies.
And C.
Require the prosecutor or the accused to adduce
D.
evidence. Require the prosecutor to place on record the reason for not opposing them.
So if you look at it there, is that really not up to the court? In terms of, you see what normally happens in the magistrate court, that's where most bail applications are held. But even here in the High Court, we deal with fewer. But sometimes the courts normally require the state to call evidence because it is opposing bail based on compelling reasons. So the court normally requires the state to do that. It's entirely up to the court. But meanwhile, the accused person would have made an application before that, isn't it?
Yes.
They would have made an application, placed their grounds before the court. Yes. So I'm saying, if does it really matter if the state needs to know what it needs to do to successfully oppose the bail. The accused persons need to know what they need to do to succeed. Whatever procedure we adopt does not really affect the discharging of that onus. It's up to you to lead an evidence. Even if the accused person start and you want to call the IO, you will still be able to do that.
My lord, maybe if the court may have a look at subsection 7.
7.
Yes.
I have seen that, yes.
So this subsection 7 is...
But we haven't reached that stage, Mr. We haven't reached the stage. That's why I'm saying it says the record of proceedings in the lower court will be relevant, perhaps, isn't it? I don't know what that means. I haven't interpreted it. Because nobody has reached a stage where they are utilizing that section. We haven't gone into the bail. It only becomes relevant if somebody attempts to utilize that section, not rely on it, and then the other objects. But why should I be interpreting all this in the opening stages?
My lord, I think if I hear the correct first, properly. It is maybe what the state is understanding the court to be saying is that it is now disregarding the bail proceedings before the magistrate
No,
court.
I haven't said that.
But if
I haven't said that.
if-
That's why I'm saying I don't want to. I'm simply asking you. Maybe it's okay. You can proceed and
yes,
rest your
what the
submissions.
state wanted to say was that we have already gone past subsection 7 because the bail application in the lower court is supposed to be by operation of law, but supposed to be part of the record in the trial. So that record is already there.
Yes.
We have gone past there.
Yes.
Yes. So that record where they were denied bail, where it was held that they were compelling reasons, and which judgment was never set aside by superior court, is still extant.
Yeah. Well, okay.
What is not before this court is maybe an application which will be made before this court. But otherwise, the application for which they were in custody at the time of the indictment came to this court to be part of the record of this court when they were brought for trial.
Thank you very
So
much.
that record is there.
It is there, yes.
Yes.
Anyway, anything else on the law?
So the issue, this issue of that it is not this application of whether the application is competent or not. It is not on the merits. It's a preliminary issue because in terms of bail, in terms of section 117A is read with section 116C subsection 2. It means that it is the applicants who have the honors to establish first whether there are any new circumstances. So if the court is to agree with the state in that particular interpretation, it means that it is the applicants who will speak first and establish. The state will only respond after they have discharged their honors. That is the circumstances, that the new circumstances which are there, they were never presented before the court, before which they were denied bail. But if we are to proceed the way my lady colleagues intend, that disregard the magistrate's court, it's not under the bridge, good riddance, now that we are here, we can start afresh. It means the state has to stand up and discharge its honors. There, that is where there is the area of divergence.
Yeah, I see. I
Yes.
hear you.
And therefore the court has to decide.
So at this stage, the state does not have any burden.
It has to, this is the understanding of the state, and the court therefore cannot avoid getting itself venturing into, because it has to decide who has to speak first. Is it the accused person in terms of 116C to establish whether there are any new circumstances, or it has to start as if nothing ever happened before?
Okay, thank you.
Yes, that is all that the state wishes to say, my lord.
We normally, in fact, at law we are encouraged to base our decisions on the law and case law. But there are times when some other literature, I think I mentioned this before, can best explain, what is happening. I will have to rule on this after so many hours because of arguments that are placed before me. But the accused person, they are waiting patiently to know whether they will be admitted bail or not. I'm sure they are not interested in these sections 116, 117. we always come up with these laws, and at the end of the day, we pack the real issue before us, and so on. It's regrettable. But my reading in this matter is going to be, that's why I said last time, just take time to read Gulliver's Travels. They describe us as a profession in very, in terms that you won't like. But anyway, my ruling in this matter is that it appears to me that Section 117 is unambiguous. that subject to the proviso to section 116, an accused person may at any time apply verbally or in writing to the judge or magistrate before whom he or she is appearing to be admitted to bail immediately, and may make such application in writing or orally. But what it means is that this is a right which is given to the accused person to make that application to the judge before whom he is appearing. Whether or not the application will succeed is a different matter. But the accused person is entitled to make that application. I am mindful of the fact that it is a fact that the accused person made an application before the magistrate court. It's a fact. It's known. It's common cause. But that does not preclude them from making an application before the judge who is trying their matter. I'm simply saying I tend to agree with the submissions by the accused person, by Mr. Judicial, that we are really bogged down on what should be the merits of the matter, which are being presented to me as preliminary issues. In other words, in terms of what should I take into account? Should I take into account the facts or the discussions in the lower court? That is something that I must determine now when we come to that stage. Who wants to rely on it? The other party may object, then I have to rule. But meanwhile, we are dealing with the bail application. Normally, an application, a process is struck off because it is not provided for in the law. But you may not strike off an application because it is not likely to succeed. Those are two separate issues. An application that is provided for can be made, and it has to be determined. I agree with Ms. Majuku that when a court is seized with an application, it must determine it. It cannot refuse because it is provided for in the law. How the parties are going to discharge their respective responsibilities in terms of whether it's an onus or in terms of being the burden is a totally different issue, but that is part of what the legislature calls bail proceedings. What happens during the proceedings? How does a party succeed? What proceedings? So I'm not persuaded that this is the objection raised by the state as merit. I am unable to accede to the request to have this application struck off. I will allow it to proceed.
My Lord,
Yes.
the state is requesting a written reason for the decision so that the Consul General can consider the issue.
That's true. That's true. Of course, that's an emotional response.
No, it's not, my Lord.
No, wait.
The state is quite settled.
No. With Mr. Maduku, we all know what our. What did I say?
Mr. Maduku.
Sorry, Mr. Maduku. It just shows how shocked I am, because you don't have to require written reasons while I'm seated here. I have given judgment. That is my judgment, extempore. Any party who requires written reasons does so in the usual way. If who knows, I'm probably going to write the judgment, even if I've done it extempore. It does happens. Or if I'm late, if I've delayed, you can always address a letter to the registrar. It's not something that you need to make in court. You are just trying to talk back to the court to say, I'm not happy with your decision.
No.
Yeah, because what you must do as counsel is to abide by the decision. If you don't agree with it, keep it yourself, and then you can appeal. The prosecutor general will always consider, I know he does, or she does rather, and you always do. But meanwhile, I've directed that we are proceeding. Let's proceed. I can't now abort these proceedings and go to write a judgment. You see how fallacious that request is. You can always make it, Mr. Maduku, Mr. Mabaudi. You can always make it, but not in court like this. I'm simply advising you, guiding you, that in terms of court etiquette, you are literally talking back to the court.
With respect to my Lord, I think maybe if that was the understanding,
Yes.
that was not the intention. The fear, what the state was afraid of, that you may make the state may, if it should decide to make an appeal, it will be a brutal enforcement after the horse has already bolted.
No, I've not granted bail. I've not refused bail.
I mean, on how to proceed, whether it is on these issues, very interesting points of
Very
view
interesting, yeah.
that
But we don't want that. I've already said, as lawyers, please, let us play our role. Let us resolve disputes. Let us, the accused persons are there. They want to know whether they will be granted bail or not. We have raised very interesting issues. I'm also very excited about the issues that we have argued. As lawyers, it's very exciting. But meanwhile, there's somebody waiting for a decision. You understand? Let us. It's very interesting. You'll be able to appeal. I'm not sure whether you are. You will have to appeal if you can. But that doesn't have to form part of these proceedings. Because even if you ask me, you don't even have to apply for reasons. I'm obliged. That's the law. I must give reasons. When I give reasons ex tempore, parties may decide to accept them. But if they don't accept them, they ask for written reasons. So that and I can't say no. Is it something that I can say no to?
In that case,
Yeah, so you don't have to make an application. I'm required at law to give reasons. That's the only time when you give instructions to the judge. You understand?
Yes.
Yeah.
In that case,
So don't worry about that. When we are done, you can even normally the preferred route is to make a written request and upload it on my portal. I will see it and I will oblige. That's all. But meanwhile, let us abide by the court, because as soon as I've made a ruling, I'm also bound by that order. You realize that?
yes.
Yes, I must proceed in terms of that order.
In that case, my Lord, if we may have an adjournment so that I can consult the principal.
On what? On what? I've already ruled that the bail application is proceeding.
My Lord, with your leave, I arrive as an officer of the court. The position is clear. These proceedings are also public, as we can see. As an officer of court, it's well settled that once a ruling has been made by our court, it binds us all in the bar. The only circumstance in which any of us here can stand if they were to apply orally for leave to appeal. Those are the circumstances. But for now, certainly in terms of our respect for the court, a judgment has been given, and we have to go to the next step. The exchange between the court and the state is, with all due respect and out of interest, out of the interest of the administrative justice, the ought not be tolerable in the glare of the public. So I'm saying this as an officer of court who is also a senior officer of court.
Thank you.
I'm indebted for his intervention. Now it's now half past 1. Instead,
You want a lunch break?
healthy break.
How long shall the break be?
And you're consulting, 30 minutes. That is the consensus.
Very well. We all need good health. We break until 2:15. But when we come back, I still haven't been answered. How do we proceed? Who is going to start? Who is going to begin? That was initially my question, which has not been answered 2 hours later.
My lord, the proposition from the bar was that it is our application, it will not be our application.
Thank you. And any problems with that?
I think that is fine.
Very well. So that when we come back, we all know where we are picking up these proceedings from. Very well. You know, we need, of course, to reboot and perhaps reflect on what Mr. Maduku said. We meet at 2:15.
Suppose we are constituted this. I see this as the
It's just to indicate that
The application that is before itself is an application for bail pending trial. By and large, my lord, we will abide by the papers filed of records. Just to give background on this matter, my lord, the applicant is appearing for yourself for trial pursuant to an indictment that was issued and set on the 7th of August 2020. Basing on that indictment, a warrant was then issued for the accused person's detention for trial. The accused person then appeared for trial. He pleaded not guilty to the charge. The matter was then postponed after the determination of an interlocutory application that he had jointly brought with the second accused person. And upon that postponement, trial is meant to proceed in February. The applicant has now made an application for bail pending trial. My lord, it is clear.
On what date in February?
On the 10th of February 2025. That is when the trial is meant to proceed.
Yes.
Yes. It is clear, my lord, that in terms of our law, a person can be detained either on the basis that the person has been arrested without a warrant, or he has been detained by virtue of a warrant. In this particular matter, the accused person has been detained on the basis of a warrant issued by the magistrate on the 7th of August 2024. So this court is first and must determine what happens to that warrant, whether or not the accused person must be admitted to bail pending the trial or not. The applicant has therefore approached this honorable court in terms of section 117.
You said this court must determine what happens to the warrant.
What happens to the what happens to the libert, to the issue of the libert?
Okay.
Or rather, is being called to determine what happens to the accused person pending trial, whether or not they are going to face their trial whilst in custody or out. The applicants has therefore invited this honorable court in terms of section 117A of the Criminal Procedure and Evidence Act. And it is the contention of the applicant that the applicant is a proper candidate for bail and must be admitted to bail. The law, my lord, is very clear when it comes to issues of bail pending trial. The starting provision, of course, is section 50, subsection 1D of the Constitution of Zimbabwe, which provides for bail as a constitutional right of an accused person. There are a number of cases that we have cited in the bail statement. Of note, the judgment of S versus Mtsaka 2016-1 Zimbabwe Law Reports 427. It's a High Court judgment. Also the judgment of State versus BT 2002, Volume 1, Zimbabwe Law Report, page 115, a High Court decision which we have referred to in paragraph number 20. And also the case of State versus Ngube 2001, Volume 2, Zimbabwe Law Reports 556, a Supreme Court judgment that deals with the provisions of Section 117. What is important to note from all those cases is that what the court must determine in determining whether or not to grant a person bail pending trial are the interests of justice. Whether or not the interest of justice will be jeopardized if an accused person is admitted to bail pending trial. It is my submission, my Lord, that the interest of justice will not be jeopardized if the accused persons are admitted to bail. All factors point out to the opposite, that in fact the interest of justice will be served more if the accused persons are admitted to bail. In the matter of State versus Atchison, 1991, Volume 2, South Africa Law Reports. Yes, it is, on paragraph number 26. They quoted this to say, an accused person cannot be kept in detention pending trial as anticipated of punishment. The presumption of law is that he is innocent until his guilt has been established in court. The court would therefore ordinarily grant bail to an accused person unless this is likely to prejudice the ends of justice. So again, in this particular matter, we see that the primary consideration are the interests of justice. My Lord, it is clear that in terms of our law, the burden is on the state to prove on a balance of probabilities that there are compelling reasons to have the accused persons denied bail. So in other words, as a starting point, the accused persons are entitled to bail. And it is the duty of the state to place before this honorable court compelling reasons why the accused persons must not be admitted to bail. And in this case, my Lord, the law is clear that it is only compelling reasons, not that the state would rather wish that maybe it's better for the accused persons to be tried whilst they are in custody, but they must really give compelling reasons. And compelling reasons have been defined as related to in our submissions to mean those reasons that would not be addressed by any other bail condition, and which are very serious in nature. So in this particular case, the question that this court must be faced with is whether or not there are compelling reasons. And the submission that the accused person make is that there are no compelling reasons whatsoever for them not to be given their right to bail. And to do this, the accused person has gone further to indicate that he is a law-abiding citizen. The accused person has indicated that when he learned about this particular matter or the investigations in the first case, he was out of the jurisdiction of this honorable country. He was in China. He learned about the investigations that were being carried out. He communicated to the officials that he was aware that they were investigating this particular matter. he had the option to stay in China. But he came. When he came, he
You
went.
mean to say he had the option not to come back home?
Not
Because you
legal.
could move to New Zealand or Australia as long as he's and it's just out of
Yes, my lord. I don't mean that he had the legal option.
No, it's not really anything serious. I'm just
Yes, my lord. But then he came, and when he came, he was released a number of times, more than 2 times, appearing and then being released and then coming back again. And when they first appeared in court on the initial appearance on the 20th of June 2024, it is common cause that they appeared coming from home. So he appeared coming straight from home to the court. He had his liberty. He did not show that he was a flight risk, because it has been considered that where there are possibilities or where there's a cogent reason of the fear that the accused person may abscond from justice, that cogent reason would then be a basis for one to say that it would be against the administration of justice, or the administration of justice is likely to be impaired if he is released out on bail pending that. But the issue doesn't end there, my lord. There has not been any reason that has been given by the state to indicate in its response that the accused person, if released on bail, is likely to interfere with evidence or is likely to commit other offenses if released on bail. My lord, we note that the state is related to the proceedings that were then launched after the accused person had appeared in the magistrate's court, where they are facing another charge in the magistrate's court. And the state seems to be suggesting that the accused persons must be denied bail because they did not mention in the bail application that they have those pending matters. My lord,
this paragraph.
in the state's response that was filed on the 27th of December 2024, the state makes the submission. Just bear with me,
Okay. So,
yes, unfortunately the paragraphs are numbered, my lord, but it's page 7 of
the state's
of 10. Yes.
Wait. This is response to the bail application
I think by the first accused person.
by
It's
by,
a response filed on
by
the,
Moses Mpofu.
yes. It's a response filed.
So it's paragraph.
It's second paragraph of page 7 of page 10. Or alternatively, in respect of the response of the state in filed on the 3rd of January 2025. I think that's the latest
Page 8 of 11.
response. It is page 8, I think. The state says that both accused persons deliberately failed to disclose that the pending case number ZAC HCR 51/06/24 involving over 9 million. That matter is ready for trial and applicants are going to be served with an indict papers during the first half of January 2025 to stand trial before this honorable court. So the state suggests for starters that if accused persons fail to disclose, then it should be a ground that they must be refused bail. That cannot be so, my lord. For starters, the accused persons disclosed in these proceedings that they are pending proceedings. It is a fact which is common cause. It is a fact which was disclosed by the accused persons
In the bail application.
not in this particular bail application, but in the proceedings that are before this honorable court, in the proceedings of the trial. And the second reason, my lord, is that in respect of this bail application, those proceedings are not relevant to this bail application because this honorable court cannot deny a person bail because there was a charge that was brought after he had been arrested. The only instances where pending cases have relevance or have a bearing which has the effect of having the bail denied is where the accused person would have committed an offense whilst released on bail. That would be an indication to the effect that there is a cogent reason why the state fears that the administration of justice will be hampered if the person is admitted to bail, because he would be likely to commit an offense if released on bail. So the administration of justice, when it comes to such reasons, relates to the propensity of an accused person committing any further offense. Any invitation by the state in its response to have this honorable court convict the accused person of non-disclosure should be, if the state feels that there has been an offense that has been committed, should be subject to proceedings of their own, and it's not relevant to the issue of whether or not they must be granted bail, in my respectful view. Then, further to that, my lord, the accused person, he has gone on to further provide that any fear by the state that the state may have when the state says the accused persons are facing a strong offense which would induce them to abscond if admitted to bail. The accused person has gone on to prove, in my respectful view, that such a fear is not based on any cogent basis. To do this, the accused person is going to ventilate the state's allegations against him, in particular the first accused person. And in doing so, the accused person contends that the state has got a hopeless case. Its case is surely going to fail. To do this, my lord, the applicant has attached to its application the indictment papers, which include the charge sheet of this accused person. One needs to look at what the state is alleging that the first accused person did personally, which would constitute an offense of fraud, which would result in the accused person being convicted. For starters, the state submits that the first accused person represented that a non-existent company existed, and that that company had tax returns, had NASA returns. So, a NASA certificate, my lord. So, the state, if we are going to go for trial, is supposed to prove that fact, that the first accused person made representations to this effect. The state tells us in its indictment papers, my lord, who it is going to call and what those people are going to say in respect of substantiating that claim. The state has listed 11 witnesses, my lord. Of the 11 witnesses, none of them ever witnessed any of the accused persons making any representation of that nature. None of them. Let us start, my lord, by looking at the evidence of Dr. John Basera. There is nowhere where the state indicates that Dr. John Basera is going to come and say he witnessed either the first accused or second accused person making those representations. It is an essential element of the offense of fraud for a false representation to have been made first. If the state fails on this hurdle to prove that the accused persons indeed made such representation, the case collapses. So that burden is on the state, and that must ex facie appear on the papers that we're going to deal with, because we know who the witnesses are. We know what the witnesses are going to say. So if we are having a principal officer of the alleged complainant, which is the Ministry of Lands, not saying that any of the accused persons made a representation that this company exists, the state is doomed to fail on that basis. But the issue does not end there, my lord. If one looks at the evidence of Dr. Obet G, the state does not intend to lead any evidence to the effect that he witnessed any of the accused persons making any representations to that effect. If one looks at the evidence of Fungai Kapfunde,
Excuse me, Mr. Judicial.
if you look at the evidence of Fungai Kapfunde, my lord, there is no way where Fungai Kapfunde is going to say he or she witnessed any of the accused persons making any representation to the effect that the state is alleging. If you look at the evidence of Titus Mbambi, there is again nowhere where he mentions this. My lord, I can go on and on to Bevan Matskamawe, Chennai Garisenet, Auban Mindurwa, Isa Precious, Spiwe Mpazula, and Henry Chapwanya. Even the IO himself does not mention that in his compiling of evidence, he came across evidence that indicates that the accused persons made a representation to that effect. So the state is doomed to fail on that point alone, my lord. But I've just looked at witness statements and summaries of their evidence, which does not disclose that material allegation. I'll go further, my lord, and look at the proposed exhibits to be relied on by the state to prove its case, insofar as it relates to the aspect of whether or not the accused persons made any representations. My lord, the first exhibit that the state intends to rely on is a Government of Zimbabwe standard bidding document for the supply and delivery of goods for the Presidential Livestock Input Pass-on Scheme. My Lord, that document is exculpatory. It actually shows that the accused persons are innocent. Because that bidding document, my Lord, shows who submitted and therefore who made representations.
Is it there? Is it attached to your application?
The exhibit itself, my Lord, it is not attached to the application, but it is common cause, my Lord.
It can be.
So, if you could just build. My Lord, it forms part of the indictment and the state papers that we were served with. And
Yeah,
it
but
is common cause.
Is it already before me?
It is not been placed before you in this particular application, my Lord. But I make reference to it because it relates to facts that are common cause, number one. Number two, this court is entitled by law, my Lord, to have reference to even hearsay evidence.
No, I hear you, but I cannot relate to what you're saying because I've not seen that document. It's not before me. I can't really. No, I can't follow what you are saying because I'm not seeing it. In other words, you are saying it says it speaks for itself in terms of who submitted it, isn't it? You know, I don't.
Yes, I know, my Lord. The point that I was driving to, my Lord, is that in a response or in its application for bail, an accused person is entitled to show the court what his defense would be. And if he manages to show that defense, if he proves it, it will have the effect of a non-conviction. It is an essential element that must then be determined by this court to show that the state is a weak case. So, on the onset, it is not the duty of the accused person to prove his defense. It is the state that must prove and give compelling reasons. So the state is simply making a bold assertion that we have a strong case. But I'm giving to you, my Lord, facts that indicate that the accused person have got a defense that is tangible and a defense that is going to frustrate the state's victory. So the state has got a hopeless case. So, my Lord, that document which the state relates to and wants to rely on is a document that will show that the accused persons did not make any representations. The state is not even alleging itself that that document is the one on which the accused persons, through which they made representations to the state. My Lord, also the state intends to rely on the general conditions of contract for the supply and delivery of the goods for the Presidential Livestock Input Pass-on Scheme between Government of the Republic of Zimbabwe and Black Deck Livestock and Poultry Farming dated 16 November 2021. Again, my Lord, this document will buttress the accused person's defense, the first accused person's defense, that this is an issue of contract. It's an issue of contractual obligations between a party which is not part of the accused person, a company which is called Black Deck Private Limited, and the Ministry of Lands, and that contract is still existent, as that contract is a 5-year contract, which that party, Black Deck Private Limited, which is not one of the accused persons, is bound to fulfill and is still negotiating with the Ministry of Lands. So it will buttress the first accused person's defense to the effect that the issue before yourself is one that relates to contractual obligations. It will also reflect the effect that if the Ministry of Lands has any issues with that contract, there are clauses in that contract, my lord, where the ministry can have relate to remedies availed in the contract. And that the ministry is not related to any of those remedies that fall in that contract. The accused person is also saying in his defense that that party which is not jointly charged or charged which is not jointly charged with the first accused person is actually in talks with the Ministry of Lands. And that party has not been charged by the state.
Who is the party?
Black Deck Private Limited. So what comes from that, my lord, is that the government and the Ministry of Lands has no issues with the third party, Black Deck Private Limited, and has not taken any steps against it, and has chosen to how the first accused person to answer to actions of a company. Further to that, my lord, the state intends to rely on the government gazette, extraordinary dated 3rd of September 2021, which does not bear any relevance to the charges that it has. It will also relate to the Sunday Mail, which has no relevance, and the state has not proved why those documents buttress that allegation that it has a strong case against the accused persons. The state has also indicated that it has, as one of its exhibits, a Black Deck Private Limited National Social Security Authority Compliance Certificate number 0197190. I would want to deal with these two exhibits together with the proposed exhibit number 6, which is the Black Deck Private Limited Zimra Tax Clearance Certificate, ITF 263, tax year ending 31 December 2021, business partner number 0200158956. And also, yes, these two documents, my lord, it is not clear. The state is not put into confidence to this honorable court why it says that those documents bolsters its case of fraud against the first accused person. Because number one, it is not the first accused person who submitted the said document. That is a fact which is proven by document number 1. Number 2, that document, even on itself, relates to a company which the state has not charged, which is Black Deck Private Limited. And then number 3, there is no one from the state's evidence or witnesses who says that they saw the first accused person cooking up those documents or manufacturing those documents or in the custody of those documents or submitting those documents. There's no one who says that, my lord. And therefore, how is the state going to win such a case where it makes bald allegations without proposing even to lead any shring of evidence to link that to the first accused person? If we just my lord. So the first point that must come out of the failure of the state even to allege or to charge Black Deck Private Limited is that they are not asking the first accused person to appear before this honorable court in his capacity as a director or as a representative of Black Deck Private Limited. They are asking him to come and answer to his personal actions, to the actions that they say he did. But for the state to say he did these actions, they must propose and they must tell us on hindsight that we are going to call Mr. Amos so-and-so, who is going to say, I saw Mr. Mpofu cooking a document which is a Zimra document, or cooking a document which is a NASA document, and I saw Mr. Mpofu submitting it. None of the witnesses is going to say that, my lord. And then secondly, even if we were to assume, which is not the case, that the state is charging him in his capacity as a director, because it is common cause and it is not in dispute that the first accused person is a director of Black Deck Private Limited. But even if we were to assume that he is being charged here in that capacity, still the provisions of the Companies Act would go to substantiate and bolster his defense if he or if the state is not intending on calling any evidence which will show that him personally as a director, he had knowledge of the acts of any of its employee in that respect. This court would not be able to convict him even if they were going to charge him in a representative capacity. But what is very important is that the first accused person is not being charged in a representative capacity, but in a personal capacity. Then, my lord, I would go to the proposed 10th exhibit, 8th exhibit, and 9th exhibit. The state intends to present the Black Deck Private Limited CR40, and they intend to present to this honorable court Black Deck Private Limited CR6. The state is not alleging that these documents are cooked or are forged. By that very same token, my lord, it bolsters the accused person's defense. That what the state is saying, that that company is non-existent, is actually false, because that company is existent. It is a company that has a CR14, it is a company that has a CR6. So, the first allegation, the very first allegation of the state is meant to fail, because the state alleges that the first accused person misrepresented that the company Black Deck Private Limited is non-existent. In other words, he represented and led officials from the Ministry of Lands to grant or to award a tender to a non-existent entity. Yet the state is going to give evidence that that entity is indeed existent. And to show this, my lord, even the witnesses of the state themselves are intended to say exactly that. I will go, for example, my lord, to the witness statements of John Basera. John Basera, my lord, is meant to state this according to the state itself. On page 26 of this application, my lord, on the summary of John Basera, paragraph, line number. Right, which says, is going to state that Black Deck Livestock and Poultry Farming was one of the 4 companies which responded to the tender by submitting its bid. So, what we must note from that is that the state's, one of the state's witness is going to tell us that this company submitted a bid. By that very same fact, it means that the first accused person did not submit a bid in his personal capacity. if he was coming to say Moses Mpofu submitted the bid which he had the offending document, it was going to be different because he's being charged in his personal capacity. But in this instant, that witness is going to tell us that there is a third person which submitted a bid. But it doesn't end there. It also says that on the 16th of November 2021, a 5-year contract was signed between Black Dog Livestock and Poultry Farming and Agritechs for the delivery of the goats. So what comes out of it, my lord, is that there is a subsisting 5-year contract that was signed by the third party which is not being charged in this particular matter, which was signed by Black Dog Private Limited. This goes to bolster the first accused person's defense to the effect that this is an issue of a contract between that Black Dog Private Limited and the Ministry of Lands. And then he's not the only witness who's going to bolster the accused person's defense, my lord. The other person who's going to bolster the defense of the accused person is one Chennai Garissa, who buttresses the evidence of Basera and who buttresses the evidence that is intended to be led from Dr. Obed Gil to the effect that on the 12th of October 2021, the witness was the chairperson of the evaluation committee in a team of 5. Black Dog Livestock and Poultry Farming won the tender. The recommendation was sent to PRAS where it was approved. A contract was then drawn on the 16th of November. And that she was chairing a committee that was responsible for evaluation of this. So, all these witnesses are in fact going to come and buttress the evidence of the first accused person or the defense of the first accused person. The other document also that the state wishes to rely on is a contract addendum for the supply and delivery of goods for the Presidential Import Pass-On Scheme dated 25 April 2022. Which document is going to buttress again the first accused person's defense that this party, Black Dog Private Limited, actually went on to sign an addendum to the contract that it had signed. And then they are also going to rely on evaluation of the tender by the ministry dated 12 October 2021. Such evaluation report, my lord, is going to bolster the accused person's defense that in fact that company, which is Black Dog Private Limited, was compliant and was found to be compliant by the evaluation committee. And then the state is also going to rely on the notification to Black Dog Private Limited dated 3 November 2021 of winning tender, which shows that the part that the Ministry of Lands was dealing with was Black Dog Private Limited and not the first accused person. And then they're also going to rely on the Presidential Goods Verification Report dated 21 August 2022 by Alban Mindurwa. They're also going to rely on the minutes of Presidential Goods Scheme.
I know you are saying the state case tends to confirm the accused person's defense. Is that,
Yes.
that's all you are demonstrating?
Yes, my lord.
Yes. To what extent is it appropriate for the trial judge to interrogate evidence before it is actually led? and tested in cross-examination.
My Lord,
In other words, what that evidence entails, whether it's likely to be persuasive, whether you really are making a detailed analysis of the evidence to be laid. Is it appropriate for this stage for the judge to make such a deep analysis of evidence to be laid by the state and make findings on it in terms of whether or not it may be sufficient for a conviction?
My Lord, I'm not asking you to make a finding on it, my Lord. I'm simply asking you to peep in, as the court is entailed to do in a bail application, to see if the defense of the accused person is plausible. If, for example, this court is convinced that the defense of the first accused person is hopeless,
Yeah, but
this
should
court would then be convinced.
Will I be
that-
able to say that? I'm just looking at both sides. Will I be able to say the accused defense is hopeless in view of the state evidence? Am I entitled to say that? Does our law permit that?
My Lord, maybe I may have used an extreme term to say.
Yeah, but it's a very good example. It's a very good
case
example.
Is hopeless.
It's a very good example. In other words, I remember this issue has come up before in terms of whether I'm entitled to express an opinion in terms of whether or not the state case is strong to the extent that you want me to go. It's the reason why I was avoiding discussion of exhibits. They are not before me. There's this term that we always use, prejudging. Yes, which is exactly what I'm trying to avoid. I'm sure the accused will not be happy to be told that your defense is a waste of time. The state will also don't want to be told that, what state case is this? What do you hope to achieve by this? Then I would be disqualified from dealing with the matter. I'm trying to discourage you from taking, inviting me to take that route.
I do take note, my Lord, of the balance that the court has to make, my Lord. And I will not traverse it further, my Lord, if it is understood in that concept that...
No, I do understand
all
all you are saying. I think you have really made your point, which you have made, that you seem to say that if you look at the state case, there's no direct evidence against the accused persons. I heard you to be saying that.
Indeed.
But in terms of analyzing what each and every witness evidence entails and the extent to which it will assist the state case, I would rather abstain from doing that.
Indeed, my Lord. So I will close on saying the state has no strong case against the first accused person. And then go on, my Lord, to then say, having said that, or try to demonstrate that the state has got a weak case against the first accused person. The first accused person is gone further, my Lord. To try and say, oh, okay, if as the state you have some fears that because of an emerging strong case against me, I'm a flight risk, I am there to assure you that I'm not a flight risk. And the accused person has presented and is tendering title deeds to his house in Harare to bolster that, to show that if there are any cogent reasons for the state to fear that the accused person is going to abscond or the interests of justice are going to be hampered, you can sell the house, which is more than $500,000 in terms of value, to show that the accused person will abide by any bail conditions that this honorable court is going to give, if it is inclined to so give. My Lord, further to that, the applicant, the accused person, has a farm that he is also even willing to give a security if it comes to that extent, my lord. But be that by and large, the first accused person is not a flight risk. The first accused person is not likely to hamper the interest of justice in any way if admitted to bail. And the state in its response has not given any indication of any ground that it says are or is compelling reasons for the accused person to be denied bail. I will now turn to the issue that took center stage, mainly at the initial stage, where the state seems to be suggesting that the state has already discharged its obligation to give compelling reasons to a magistrate when the accused person initially appeared before the magistrate. And the state seems to be suggesting that that issue has been determined already, and there is an extant court order of the magistrate court. My lord, I will start from responding to that by reference to the case of his lordship that I have referred to before, the case of Mpofu and Mike Chimombe versus the state, HH 409 of 24. HH 409 of 24, where this honorable court went correctly so in my respectful view.
Don't flatter me.
I'm here to flatter you before and say that the judgment is correct. But anyways, the court went at length to traverse the provisions of Section 66 and their effect in respect of an accused person who is in custody. And the court held in this judgment, my lord, that where an accused person is in custody and he has been indicted, in terms of Section 66, especially subsection 2, the magistrate court must issue a warrant for the detention of the accused person. In my respectful view, my lord, the effect of that warrant being issued for the detention of the accused person is because his status of detention changes at that moment. It is no longer a detention because he has been denied bail. I must state that it is common cause that the accused persons once applied for bail and they were denied that bail, and bail proceedings transpired in the magistrate's court, and they attempted to appeal against those bail proceedings. And this honorable court made a ruling on that, a judgment which I will also come back to. But in this respect, I wish to relate to the provisions of Section 66, subsection 2, in comparison to provisions of Section 169 of the Criminal Procedure and Evidence Act. Because I had heard my friend to be intimating that provisions of Section 169 are applicable to this honorable, to this situation, which I differ.
Did you say they are applicable or they are not applicable?
That was my interpretation. I may have been wrong. I will
So
hear
just what is it, so that you can make meaningful. Did you say they are applicable to the accused persons?
Not applicable.
Thank you.
I'm glad that we are on the same page. So the provisions that are applicable are provisions of Section 66, subsection 2. So the question that, in that case, that this court must be faced with is, how are the accused persons appearing before it? Is it on the basis that they've been denied bail before, or is it on the basis that there is a warrant for their detention? And in my respectful view, the answer to that question is that the accused persons are appearing before yourself in detention on the basis of nothing else other than the warrant that was issued for their detention on the 7th of August 2024. So, in other words, this court is not sitting to look at the proceedings of what transpired in the magistrate's court in their bail application when they appeared on the basis of a Form 242. Because the accused persons are not appearing to this honorable court on the basis of the Form 242, but on the basis of a warrant of detention that was issued by the magistrate's court. That is the first reason. The second reason that I will give to say that the proceedings of the magistrate's court are not relevant and should not be taken into regard, or that this court should not regard that what transpired in the magistrate's court is now res judicata and it cannot be traversed again, is that, number two, this honorable court, having been faced with an appeal by the accused persons against that determination of the magistrate's court, held that determination of the magistrate's court was moot. And by finding that the decision of the magistrate court was moot, this honorable court was in effect holding that they are not applicable and that the accused persons could not litigate successfully an appeal against moot proceedings because they were no longer of use, they had been overtaken by events. So this honorable court exercised its discretion and even refused to entertain the appeal.
No, I did. I entertained it.
Indeed, my lord.
It.
Indeed, my lord. This honorable court dismissed the appeal on the basis that the decision of the court was moot. So the effect of a finding of this honorable court that the proceedings of a lower court are moot would go against the submission that the state is submitting, that the judgment of the court, of the magistrate's court, is extant. It cannot be extant if it is moot, if it has already been determined to be moot. So, for that second reason, in my respectful view, the submission of the state would not be applicable to this particular case. And then, thirdly, this honorable court referred in the judgment that I've referred to, in the judgment of Mpofu and another versus the state, HH 409 of 24, to what transpired before the honorable court in the Chinanga case versus the state, where His Lordship Justice Matonzi, as he then was, after postponing a trial that had been intended or slated to be had to deal with the issue of bail as a fresh, I'll use the word, as a fresh bail application, and entertained it in that case. So, in my respectful view, the submissions by the state in that regard are not plausible. The last aspect, my lord, that I will deal with are the personal circumstances of the first accused person, my lord, which have been dealt with in my submissions. He is a family man with a huge family. All his main interests, business interests, are vested here in Zimbabwe. He has a farm that is here in Zimbabwe, and all his children are in Zimbabwe. So there's no way he undertakes that there's no way he can just run away from his family because of these charges that he's facing. My lord, before I take leave to sit, if I can be allowed to just defer with my clients.
Do you want to talk to your client?
Yes, my lord. Yes, my lord, I was minded by my client that he undertakes and is willing, my lord, to surrender his passport as indicated in his bail application. He is also undertaking and willing to abide by any reporting conditions that the Honorable Court may give. He has even indicated that he is willing, even if it entails that this court gives stringent conditions, to report even twice a day until this matter is finalized, to show that he is really willing to have this matter determined. Other than that, my lord, unless if you wish me to clarify on any other point, those would be my submissions in motivation of that.
Just one point. Section 1, you said section 169.
Yes,
keeps coming back.
Yes.
The state and the defense have said it does not apply. Can you unpack it for me? Maybe you read it.
Yes, my lord, thank you. If you could just bear with me.
You just read it slowly so that I understand. And then you demonstrate to me why you are saying that. You have both said it doesn't apply. Obviously, you rely on your interpretation of it. I want to be assisted by appreciating why you say so.
If you could just bear with me in section 169. Right. Section 169 says, my lord.
Of the Criminal Procedure and Evidence Act.
Yes.
Can you read it slowly?
Yes. Termination of bail on plea to indictment in High Court. That is the heading. If the accused is indicted in the High Court after having been admitted to bail, his plea to the indictment shall, unless the court otherwise directs, have the effect of terminating his bail, and he shall thereupon be detained in custody until the conclusion of the trial, in the same manner in every respect as if he had not been admitted to bail. That's what it says verbatim, my lord.
Yes.
My interpretation of this, with respect, my lord, is that it is applicable to an accused person who has been admitted to bail.
And what does it entail? What is that person? How does it apply to that person?
It comes, my lord, from my literal interpretation that it says a termination of bail on plea.
Yes. Does that person whose bail has been terminated apply for bail? In terms of Section 117, what does he do?
Yes, if we are assuming, my lord, that, for example, the first accused person had been admitted to bail, and he takes a plea.
Let's approach it from an abstract point. Let's just, you are just interpreting it for me.
Yes.
You need not really,
Okay.
Relate it to me. I want to know what it means generally. Does it mean that somebody who was on bail before pleading to a charge, and whose bail is terminated by operation of Section 169, applies for bail in terms of Section 117A? Is that what it is saying?
The golden interpretation, my lord, I would say, favors that interpretation, because it says that upon pleading to a charge, if the person had been admitted to bail, that bail is terminated.
Unless? What does it say?
Unless, it then says, unless the court otherwise directs.
Yes. What does that mean?
Yes.
Directing what?
So the court may direct mero moto. This is
directing what?
Otherwise, it may direct that he be admitted to bail. It may direct.
No. He's already on bail. It has just been terminated by operation. So what is the court doing? What is it directing there? Is it receiving a fresh bail application, or it is recognizing the order, existing order, or it's in other words, the court is allowing the accused person to remain out of custody in terms of the obtaining bail conditions granted by the magistrate. In other words, is it a matter where the accused person must stand up and say, I live in Borodale, I have a passport, I have all this, or is it a question of where the court does not do it mero moto, of course.
Yes.
Naturally, we agree that an accused person can motivate,
Yes.
can request a court to invoke that.
Yes.
Is he making a fresh bail application where the state must then show compelling reasons, or the court is simply saying, is simply allowing that bail which is in existence to continue applying? What is it doing? What is happening there? What are we being told by Section 169?
My Lord, my interpretation stems from Section 66(1). Section 66(1) says that if an accused person is indicted and he has been admitted to bail, that bail stands on those conditions until he appears on the trial date. So I believe that when the accused person then appears on the date of the trial date, this section is to such an extent that it is not binding this honorable court to the determination that has been made already by the magistrate's court or to the effect of Section 66(1), but is giving latitude to this honorable court to determine what happens pending trial. Mero moto. To say, okay, now I want you to report twice, or now I want you to report a month, or...
Literally, let me follow. I want to follow. A person who is on bail, who is indicted,
Yes.
continues on bail on the same conditions.
Yes.
In other
In terms
words,
of Section 66.
yeah, by operation of that Section 66.
Yes.
In other words, of course, we know what happened here.
Yes.
Previously, bail used to be terminated,
Yes.
but now it's no longer terminated on indictment, isn't it?
Yes, it's now terminated.
You continue on the same conditions, okay?
Yes.
When the person appears before a judge and he has not pleaded,
Yes.
the bail conditions remain.
Yes, in terms of my reading, my Lord, is that in terms of Section 60, prior,
169.
You have related to what used to happen, my Lord. That
Yeah.
upon indictment,
Bail.
it had the effect of terminating
Yes,
bail.
yes.
So my respectful view is that the amendment that was introduced by virtue of Section 66(1) was that the termination is now no longer applicable at indictment, but
Yes.
it's now applicable on the day of the trial.
Is that so?
That is my interpretation.
Not on pleading to the charge.
On pleading to the charge, yes. my
Yes.
Lord.
So
That
in
is
other
my
words, the accused
interpretation.
person might appear the first day.
Yes,
He may not be asked to plead.
yes,
Okay?
yes,
It happened in this case. They were not asked to plead on the first day.
yes, my Lord.
The bail remains, assuming they were on bail.
Yes,
Isn't it?
Yes,
Then when they plead,
yes.
the law takes away the bail.
It
In
says
layman's
it's-
language.
Yes,
It takes away the bail.
yes, my Lord.
And then the court may direct otherwise. In other words, the court has the discretion to override that particular legal provision which takes away the bail and say, okay, it will continue. I'm saying that's what I want you to help me.
Yes,
Is the court ordering that the bail will continue, or is the court at that stage hearing a bail application in terms of which then releases the accused, or it's just recognizing the bail? What is happening there? Because we know what happened in terms of Section 66.
Yes.
The same bail conditions. In other words, the law is recognizing the bail. It's
Yes.
giving it. The accused person has pleaded to the charge. The law takes away the bail.
Yes,
It doesn't. That doesn't involve the judge.
Yes.
It's the law taking it away.
yes.
Okay. The judge might well say, "I'm aware of that. I will allow the accused person to remain on bail, even mero moto, as you
Yes.
say."
Yes,
But the judge may not.
yes, my Lord.
In which case, naturally, you may invite the court to consider that option. There's nothing wrong with that.
Yes, my Lord.
Well, now, at that stage, what are you doing? Are you making a bail application, or you are simply moving the court to to do what Section 66 did, to allow that bail to continue? What is happening there?
My Lord, my respectful submission is that the effect of this section is not to subject this honorable court to the determination.
That's the effect.
Of
We
the
all know
magistrate.
that.
Yes.
It gives me the power as the judge. Let's talk about me. I'm the one dealing with this matter.
Yes.
It gives me the power to override it
Yes.
and say, no. In the interest of justice, you'll be free. But what, in terms of what procedure? That's what I'm saying. Is it in terms of a bail application, or is it just in terms of exercising my discretion to allow? In other words, if it, maybe let me put myself clear. A bail application is where you are doing what you're doing now,
Yes.
and you are offering conditions. In other words, I would be you are literally asking me to even decide the bail conditions.
Yes.
Okay.
Yes.
As if they were not set before.
Yes.
Isn't it? But is that what 169 entails? Or it is saying to the judge may allow the accused person to remain on bail on the same conditions. I'm not very sure about what it means. That's why I'm inviting you to make submissions on this point.
Yes, my Lord. The submission that I'm making, my Lord, is that Section 169 has the effect of terminating bail to those that had the
Yes.
bail.
Yeah.
And it's up to those. There are now two scenarios that are then introduced by Section 169. The first scenario is where the accused person may then choose to do what the applicants have done in terms of Section 117A. Because Section 117A is clear to say at any time a person can motivate the court to give
So
bail.
all you are saying is that if the court hears a fresh bail application,
Yes.
the
effect of Section 169
It's not because in terms of Section 66, you took me through that. There's no question of bail application.
Yes.
The law is giving life
Yes.
to an existing bail.
Yes.
We should, otherwise be affected by enactment.
Yes.
169, what is it doing? Is it giving the judge the discretion to give life to the existing bail, or is it saying the judge must now hear an application?
Yes, my Lord. What I'm saying is that Section 166, Section 66(1) gives life to a point of the first appearance, or to a point where the accused person pleads.
Yes, which means that there's no question of a bail application, there's no question.
Yes.
It's just giving life.
So-
now you get to Section 169. It's no longer, I'm saying, what is the judge doing there? Is he hearing a fresh application, or is giving life to an existing bail?
In my
order?
respectful view, my Lord, you'll be hearing a fresh bail application.
Yes.
You'll be considering the issue of bail as a fresh issue, as a court of first instance. And the effect is that he's not being reduced to be bound, as what my learned colleague was suggesting. Because my learned colleague was suggesting that whatever the decision that was made by the magistrate's court binds this honorable court. So, in the two separate scenarios of Section 66(1) and Section 169, and in the second scenario, where an accused person was in custody of Section 66(2), in both scenarios, when the accused person pleads, it becomes a fresh issue. In other words, Section 66 in both 1 and 2 is just a conveyancing bail to transmit an accused person, whether in custody or out of custody, to the trial judge, who then determines the issue as a first issue of first instance. So in this particular, the only reason why I say it's not applicable is not because I am saying in Section 169 it would not be a fresh bail
So a
application.
judge who may also decide that the accused person will remain out of custody, then sets new bail conditions.
You would have acted in terms of Section
Yes. In other words,
169.
he says, okay, you were on bail. I am aware that the law has taken away your bail, but I want you to continue on bail, and you shall deposit 2,000. You shall what? In other words, without even hearing evidence, the judge just says, I am setting conditions.
Of course, my lord, there are other tenets of justice that maybe the court may have to seek to give audience to the state and the parties. It must indicate what is
what it is inclined to do.
Yes, and then it then makes a decision. But Section 169 gives it the right to make that determination merimot. In other words, if none of the parties make submissions on the issue of the bail, the court can invite, even though there's no application for bail, for the parties to address it.
To address it, yeah.
Yes.
Okay, well, yes,
and then
yes.
make a decision. It would have acted in terms of one section.
Yes, and then the last part. What does it read? The last sentence.
The last sentence, my lord, says that
The last line.
the last line, and ye shall thereupon, where the judge directs otherwise.
If the judge does not direct otherwise, what is the consequence?
It's silent. It says, and ye shall thereupon be detained in custody until the conclusion of the trial, in the same manner in every respect as if he had not been admitted to bail.
Mm-hmm.
Yes.
So what is it telling us about those who have not been admitted to bail?
My lord, I would submit that it tells us nothing about those who have not been admitted to bail, because it relates to termination of bail first. So the trigger there is the termination of bail itself in the first instance. So if bail has been terminated and the court does not
the person is expected to remain in custody
as
in
if
the same way. Which
Yeah.
way? As if.
Yeah.
Well, okay, those words are just superfluous, isn't it?
Yes, my lord.
They are not. They don't mean anything.
They don't know that. But what is clear from both scenarios is that in that later scenario, my lord, where the court has granted bail, maybe on more stringent conditions.
I don't know if I were to paraphrase it. I'm understanding that a person who has not benefited from the discretion of the judge to remain out of custody is to be treated like a person who is to be remain in custody, to be treated like a person who has not been admitted to bail.
Yes.
What does that mean?
It means he remains in custody. He has to be in custody
Until he applies for bail.
until he applies in terms of Section 117A. Yes. But then the point that I wanted to make, my lord, was the effect of the decision that is made by the court, in either in terms of Section 169 or where then a person makes an application for bail in terms of 117, where the person had been in custody as the accused person, is that that person, if aggrieved by the determination of the court, will have a right of appeal to a superior court. In other words, the issue of bail would have been dealt with as a court of first instance.
Okay.
Either in terms of operation of Section
that's
169.
not for me. I'm not a court of appeal. In this case, I'm a court of first. You are making that application before me. If you think that I don't want to decide for the superior court, I can't express an opinion.
All I was saying, my lord, was to give a purposive interpretation, to say that the reason why the legislature couched it in this way was to create a scenario where a person has a right of
to a higher court.
To a higher court.
Okay, that's
Rather
fine.
than to say, oh, you were tried in the magistrate's court. That's
So,
that.
so you are saying if the judge does not, if the judge, in the excess of discretion, does not order the release of the accused person who has pleaded, that decision is appealable.
Yes.
Oh, I see.
Yes, my lord. And this buttresses the point that I'm making, my lord, that as in this case, where because of Section 66, subsection 2, the accused person cannot, in terms of the law, exercise a right of appeal against the magistrate's court, because that decision is moot and is not appealable. So the effect is such that they are allowed, now that they have pleaded, to make an application for bail, in respect of which a right of appeal would then be heard in another superior court.
Thank you.
Yes.
And then finally, is the requirement to inform the court, to take the court into one's confidence in terms of pending charges, peremptory?
My Lord, every litigant,
The issue that has been raised by
in terms of the law, is generally supposed to put the court into confidence and place every material fact.
What does it say? What does that section say?
The section that was quoted by the state, my Lord, in this regard is, if you could just bear with me, is...
Can you just read it
if
slowly?
If we just
For the record? It's around 11775. 117A, subsection 5, I think.
Yes.
Can you just read it for the record? I think it's also quoted in the state response. You are the one who drew my attention to it.
Yes, it's
What does it say?
I'm at 117, but 1175 is saying, notwithstanding the fact that the prosecution does not oppose.
No, 117A, subsection 5.
It says, in bail proceedings, the accused is compelled to inform the court whether the accused has previously been convicted of any offense and there are any charges pending against him or her, and whether he or she has been released on bail in respect of those charges. That's what it says.
So is that peremptory or not?
It's peremptory, my lord. The accused person, like in any other proceeding, is required by law to place facts before the court. And then it goes on, my lord, to then says...
I know it says the accused who fails to do so or refuses or whatever is guilty of an offense.
Yes. Yes, my lord. So
I don't have to concern myself.
So the submission that I'll make, my lord, is that assuming there's been willful non-disclosure by an accused person, this section is there to create an offense. It's not there to be a relevant consideration in whether or not to grant bail. So in other words, if the state has qualms with it and think that the accused persons have willfully non-disclosed anything, they can press charges and a trial will be held. But it does not invite this bail court to convict the accused person and to sentence them to not giving them bail because of
No. Nobody asked me to do that.
Yes, my lord. I
Nobody
just
asked me to. I just
clear
wanted
because I
to.
did like.
No. I'm simply asking whether it's peremptory or not, because the state is saying the accused persons were entitled, were required in terms of the law to make that disclosure. I don't want to deal with a crime which is not before me.
Indeed, my lord.
An alleged crime which is not before me. No.
Indeed, my lord.
Yes. And other submissions?
Yes, and also the accused person have gone further, my lord, to indicate the reason for that seeming non-disclosure.
What was the reason, by the way?
The reason is that it has been disclosed already in proceedings that are before this court, in the trial proceedings themselves. They disclosed this fact. So they thought that it was a factor which was which was already in the domain.
Did you disclose it at the trial?
Yes, in the application for constitutional court referral, they did when they took the stand. They indicated.
So all those proceedings are relevant.
I'm not saying they are relevant.
In the sense that I can consider what evidence was
They're
taken.
only relevant to show that it is not willful non-disclosure.
Oh, I see. Thank you. In any event, they are not being charged with that. So
In any event, they're
you
not
don't have
charged.
to belabor the point.
Indeed.
Yes. Anything else?
Nothing else, my lord.
Mr. Manduku.
Thank you, my lord. I think likely we won't be as long as our learned friend. We would first admit that we abide by the application that is on record. So every statement in our application stands. We are also taking note of the fact that we may not need to go into the details of the second accused defense outline. I think from the exchange that has taken place. So we would not need to do that. But our starting point, my lord, we are really supplementing to the extent necessary. Our starting point is to note that this application is before the trial judge. And that is significant in itself. It cannot be wished away. It's an application made to a judge, but this is an application to a trial judge. The judge who is sitting to determine this application is the same judge who is seized with the trial, the same judge who has already had the allegations read against the accused persons, who has also had the defense of the accused persons. I think that is how far the element relating to the strength of the state case must go. It would appear we respectfully submit this to avoid a situation where there is preempting of the trial. Judges exercise discretion, and that in the determination of the bail application, the judge ought to take into account what he already has without the parties making arguments on those points. That is the submission we make. Because before the trial, judge, it has to be taken into account. Our second point, my lord, is to enter into the debate, not so much of a debate, but what was going on in respect of section 169, section 66. We need to put our view and our submission in that regard. We respectfully submit that a judge of this court cannot act mero motu in respect of any matter that relates to where there is power that a court can grant. A court must always act pursuant to an application. So even where section 169 that says unless the court so directs, the court can only so direct if an application is made. And here we want to make reference to what has become now a locus classicus, is the case of Zara and others, versus Kashumba, Zara and others versus Kashumba, is SC 18 of 18. It's now reported, but I do not have the reported.
It's SC?
SC 18, Supreme Court Judgment number 18 of 18, but it's now reported in the 20...
13.
Yeah, 18, 2018.
Sorry, let me take the citation again. 18 of 30 of 2013 or of 2018?
2018.
Of 2018.
Supreme, yeah, it's 1818. Supreme Court Judgment number 18 of 18. Yes. It's now so locus classicus is a judgment by Justice Uchen. And time in and time out, the Supreme Court emphasizes that in our jurisprudence now, a court cannot act mero motu. It must maintain impartiality, strict impartiality. Its decisions must always be based on an application. Even where it's so obvious, someone must motivate, which is why it's even an application for condonation. If you don't seek condonation, you won't get it. We've had situations where the court says, look, I would have granted the applicant condonation, but no application was made. So in this case, we cannot avoid section 117A, subsection 1. That's the point we are standing to aid. They ought to be bail application. So what it means, section 169, and we respectfully submit, it has opened our eyes to the fact that what the legislature wants is that this court must not be bound by the magistrate's court, generally. I mean, so in section 169, if by that time, because what would happen there is that in 169, all accused persons are equal. Once you plead, then your bail disappears. That's what by operation of law. this will also apply to that accused person who would have been likely to have been granted bail by the magistrate court, and then they are told by circumstances that that bail stands. It only stands pre their pleading. So that accused person will also still lose their bail when Section 169 enters the scene. Which means that any bail that a person who is under trial in the High Court gets is bail pursuant to an application made before the judge of the High Court. You might have got it before. Our clients didn't have it. But those clients, other people's, they would all lose their bail at 169. So if you can to enjoy bail when you are under trial in the High Court, it must be bail granted by the High Court. That is the submission we make in respect of Section 169. So this is why, in terms of the application that is before you, the state is suggesting, I'm not sure whether they will persist with it, given the long day we've had and this issue keeping coming up, whether they will still persist that they want us to go back to the magistrate having accused. We respectfully submit that if we read the statute properly, it would be to treat these people in an unequal manner. A person who has been refused bail by the magistrate court, if you take into account, you are taking the prejudices of the magistrate court to his court. That's what it means. But the other one, the only time you can go in terms of the accused is when they have been granted. That's what, they have been granted bail. So you cannot disregard it because it's in favor of an accused. But anything which is adverse to an accused, which would have happened prior to the trial, we respect to submit that it ought not be taken into account. What I am now submitting, because I want to just summarize our point there. We respectfully submit that the court is faced with two novel situations, and we cannot pretend that it's not novel. The first one has already been resolved by this court, which is the effect of an indictment. The judgment that my learned friend referred to, which is the judgment of this court, has dealt with that issue, but was novel, and we have not found any other case dealing with that matter. This court is actually bound by that unless there are positions. That's how the doctrine of stare decisis. It is not, my Lord, with respect, your judgment. It is a judgment of the High Court. And that judgment is binding on you unless you are persuaded by the state that you should not be bound. But that's a novel situation which has arisen. Then the second one is the issue that relates to where bail had been previously refused by a magistrate but had been overtaken by an indictment. Whether in fact the proceedings of the magistrate can actually be taken into account, and our submission has been that it is not relevant, and that if the state wants to rely on those proceedings, it must itself rely on them, but to demonstrate, to discharge its burden of whether or not they are compelling circumstances. But those two situations are really novel, that the court has to keep its mind clear on that, on those aspects. And we submit as we have, which leaves us with the submission that the only reason, once a bail application has been made, which can stand in the way of a bail application, is that there are compelling reasons, which is what the Constitution says in Section 50. So the only issue before you is, are there compelling reasons to deny the accused person's bail? We so submit and strongly so that that is the only consideration. Are there compelling reasons? Although we have started in putting across our belief that there are no compelling reasons, we obviously would be on our feet again if the state claims that there are compelling reasons and suggests that there are when we respond. But there is only one. And here, if we may be of assistance to the court, we have seen that in the Act, our Act, the Criminal Procedure and Evidence Act, is made up of 3 types of provisions. There are the pre-independent provisions which stand out there. There are many of them. Then there are some provisions that stood out post-independence but before 2018. And then there are post-2018 provisions. if I may be allowed to make that reference. I think just for the guidance of the court. And whenever we deal with this act, whether in this court or elsewhere, we get difficulties with that. The act has not been completely harmonized to read as one statute. Sometimes you have 3 different statutes in one statute, because, which is why you see section 169 sitting on its own somewhere, and why it would not be flowing the provisions in section 66. Ordinarily the provision in section 66 would have been sitting around the same provision in section 169. What do you want to do with the bail? You get something in section 66, and then you go all the way, you get something in section 169. It's because of that aspect, and I think with time these things will be harmonized. But the rule of interpretation is that a statute must be read as a whole, and that provisions must be read together. And our reading of those provisions is quite clear that you only refuse bail if there are compelling reasons, and that where a person is under trial in the High Court, it must be the High Court itself that determines whether pending trial that person can be on bail. That is our reading, my lord, of it. I think it's an unmistakable conclusion. The High Court cannot have someone out of custody merely on the basis of a decision of a magistrate when the trial has already kicked. That's what the statute is saying. Now, when I was sitting, my lord, I came across the fact that the remand proceedings actually do not say that a person is detained pending trial. They actually don't use that. They either say that you are detained pending a charge, or you are detained for an alleged offense, or you are detained until dealt with in accordance with the law. Which means that when a person now is detained pending trial, if it is in the High Court, it can only be after committal. That is the time.
You are reading from section.
I was reading section 50 of the Constitution. It is one that has all those expressions. Section 50, subsection 1, D, then section 50, subsection 2, then section 50, subsection 6.
Wait, I need to open the Constitution. And we are concerned with section 50, subsection?
We are concerned with section 50, of course, subsection 1D, which is the one for the right to bail.
Which, Section 50?
Section 50, subsection 1D, would, it only talks about, I think, detention pending a charge. Whatever. It doesn't refer to pending trial.
I think that is at a police station. I think we are dealing with subsection 6.
Yes, subsection 6 is the one that then introducing detention pending trial.
Yes.
Which is different from section 50, subsection 2.
Oh, so you are saying in the magistrate court, what is being given effect is the right in section 50, subsection 1?
Yes, it's detention pending a charge or detention for an alleged offense. It is not detention pending trial. That is the point we are making.
Oh, I see. Let's see. Oh, that's interesting. What does section 117 do?
Thank you, my lord, for that. Because I was going also to go to section 115C. So if we go to section 115,
yeah, you can follow any order which suits you.
So what it says in section 117, which is entitled, it says subject to this section, a person who is in custody in respect of an offense shall be entitled to be released on bail at any time after he's appeared in court on a charge and before sentence is imposed. So there is no reference to pending trial. You are in custody in respect of an offense.
That's section 11.
That's 117.
117.
Then there's section 115. I think it will be also important for you, my lord. Section 115, subsection 115C, sorry, 115C, subsection 1. If the court is there, I may need to read.
115.
Yes, 115C. That's
Yes.
I want to read that. It says, in any application, petition, motion, appeal, review, or other purpose before a court in which the grant or denial of bail, blah, 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 the grounds specified in section 117 being the grounds on which a court may find it in the interest of justice, that an accused person should be detained in custody. That's where the emphasis is, until he or she is dealt with in accordance with the law.
Mm-hmm.
So there's a deliberate avoiding of who is detained pending trial. You are detained for various reasons. You can be pending a charge, pending an offense. In other words, what we want to argue, if we want to be open with what the process is, we want to argue that when you have that bail before or refusal or acceptance of bail pending in the magistrate court, it is not the same sort of bail with the bail that you seek pending trial, which is provided for, like the bail that we are now seeking. It's a very different one. It is in a class of its own. In fact, that is the first time ever that a person can ever make that application. You recall, my lord, that...
No, in other words, a person who has been denied bail at initial appearance is entitled, well, I think maybe that would... such bail, whatever decision, kind of expires when he is about to be tried.
That's what we're saying is that bail disappears by operation of law. I can imagine the difficulty that the state has. It knows that there was a bail refusal, but we are lawyers. We know what we mean when we say by operation of law. By operation of law is when we are not like the lay people who find it difficult. We know that by law, there is no bail thing, there is no bail refusal. It has expired. It's no longer relevant. And it cannot be resurrected in any way, even when the statutes themselves make it clear that that kind of application for bail is a bail pending a charge or a bail for an alleged offense. It is not bail pending trial. That's the argument I'm making, my lord. And this is what I find. I don't find it. It's not. If we get to section 51, it actually says you are detained pending a charge or detained for an alleged offense, but you are not detained pending trial. The first time then you are really pending trial in this court is like when you are appearing before a judge of the High Court and saying, I am applying for bail. That's our argument. And we are trying to cement the fact that this is not, in terms of section 116, a further, whatever, a further application. That's the point we're making. So I'm done with that, I just want to, we wanted to emphasize that point. Then turning to the application itself, my lord, we have explained in the application the basis upon which we believe that the second accused is entitled to bail. The most important aspect of it all is that the accused persons themselves were not treated in the same manner that other people who appear in the courts from home are treated. I can say that the court can take judicial notice. Even Mr. Mabaud will testify to the fact that whenever we represent clients in the magistrate court and you are coming from home, the language that is used to say, are you coming from home? And if the answer is yes, the court says, so issues of bail do not arise. That's the language that is used. It's always, and I read it there myself, I didn't know about that, that statement, which says, so issues of bail do not arise. And it's no one at the magistrate court ever questions people. Now, in this particular case, that's a big departure. They were in China, as my little friend has indicated, they come back home, they are relaxed, they go to present themselves to ZAC, walk to the magistrate's court and so forth. I mean, then suddenly things changed there. That was really the attitude. These accused persons can only appear to be some risk or threat merely because of the decision that was taken by the magistrate court to deny them bail or to make issues of bail where there were no issues of bail. The public might actually think that the two accused persons are such serious persons that their case, I mean, like we are on air, it's live streamed, it's one of these. But it's not a real case that one could say is out of this ordinary. It was the extraordinary step of discriminating them from those people that come from home, which has led to where we are and the struggle that they've gone through to get bail. I would say, with respect, my Lord, it's actually an exaggerated state of affairs. Now, having said that, so in that case, they will be good candidates for bail on the conduct that they have. Now, when I opened, I said they are before the trial judge. Here, you forgive me, my Lord, if I overstep. But when you are before a trial judge, you would have appeared before the judge. The judge would have seen you, and so on. You've interacted with them, at least from your position. The court must be able to act on the basis of whether these people appear to be such that the courts are experienced in dealing with people. It must be taken into account. The court must take judicial notice of the conduct of the accused persons from the time that they appeared in day one. It's a trial before a trial judge. He would have some idea of what these people are. I get surprised myself, and I say so with respect, that these individuals that we are representing appear, if I use the word dangerous in court, only when we are arguing their matter. But when you interact with them, when you find them, even when you visit them in prison, the atmosphere is all warm and everything. And you ask yourself, why are they in custody? And I must raise it. And I want to refer to the case of Aitken and another versus Attorney General. Just for the point I'm making, my Lord, about the court must take into account these things. Aitken and another versus Attorney General is 1992, Volume 1, Zimbabwe Law Reports, 249, Supreme Court. And I would refer the court to, I think, page 254D to G of the judgment of the Chief Justice Garland. I'm saying this, why I'm citing this case, the favorite case. There, the Supreme Court was dealing with Aitken, was a well-known lawyer. I mean, well-known. The Chief Justice and others in court knew him as well. But of course, here they were sharing a situation where they are judges, but he's a lawyer, and the state was opposing bail all over the place. What the legal practitioners for Aitken did were then, of course, to offer bail conditions, more or less the ones we have offered here. And the court was alive to the fact that, look, this person won't run away. We know you've said, but imagine, there, of course, if you look at the bail conditions that Aitken did, he was a fairly privileged white person. I said so with respect. So he could surrender much more than what the accused persons here were prepared to surrender. But the reason why I picked the Aitken case, because it was then, the sentiments in Aitken were then taken by the Chief Justice in State versus Chimombe, 2002, Volume 2, Zimbabwe Law Reports, 209.
2002? State
versus Chimombe, 2002, Volume 2, Zimbabwe Law Reports, 209, S, Supreme Court. Chief Justice Kigosi, who took the sentiments, which have to do with you ascribe to an accused person the ordinary motives and fears that, of course, we're human beings. But I know that this is it normally is misunderstood by courts. They use that quotation to say you ran away. But that quotation was put in the context that we are all human. We understand these things. There's no way Aitken would go and so on. In the same way that I will respectively submit that for the accused person, and I'm speaking for both of them, if in their position they are able to surrender their title deeds in the respect of the accused person I'm representing, he actually has a piece of land that is offered which is actually a family home, to believe that in this situation, if after surrendering all that, he will run away and risk that his family will lose its home, is to depart from the sentiments in Aitken and said, we should behave like that. That's the point I'm making. I think I don't want to continue with that. I'm just saying we are appearing before a trial judge. The trial judge would have known us, would have interacted with the accused persons, and on the basis of general motivations and so on, I think it must be treated in the way in which courts would. They must take judicial notice of this, which is why I think in my experience, my lord, it's very rare for even high-flying candidates, they are not, but for a person who is facing a fraud charge, to be tried from prison, it's fairly rare. If they are, it's fairly rare for that to happen if there are persons of means who can surrender, because at the end of the day, what we want to do, even if they are to be convicted, is to send a message that crimes do not pay. And if you have to surrender, like in this case, $3,000, $5,000 US, you surrender title deeds to your, and then you have surrender your passport. This case has been also quite publicized. I don't see where they will run to. Sure, they will be identified anywhere they go. That's my experience. I mean, if any one of them were to be find somewhere in the streets in Hong Kong, I'm using Hong Kong because Ms. Mabaode was talking about Hong Kong during the break. But if they were to find themselves, he was telling us that it's an hour from Hong Kong to mainland China by train. I'm just my local salary. So if the accused persons were to find themselves in Hong Kong, they will be identified. And so I'm pleading with the court, apart from what we have said, that this is a real proper case that if we look at all the circumstances of this matter, the court must weigh in, allow the accused persons to be tried from home. It can increase the bail conditions. They've been in custody for now it's over 6 months. Even the public, only that we can't do a referendum. I think the public would say that, well, we have seen and heard enough of Chimombe and Mpofu. I think that they can, because they will not be released. All what we are applying is that they be allowed to, and otherwise I'll abide by. We had initially indicated that we had wanted this to deal with, but we are not now no longer going to do it. It's not necessary to go into the defense. We would say that to the court if it takes into account the factors that are in section 117.3 and so on. It doesn't have to. It has simply to take into account the issue relating to the strength of it. It doesn't have to go into place. So it will be enough for the court to say, regarding the factor, regarding strength and so forth, is already tried. I would not want to preempt my ruling. They get to look at the other factors. But if you look at all the other factors, they will point towards the fact that the accused persons are good candidates for bail. Then I want to close by saying, if you were to be not with us on the issue relating to whether this is a real fresh bail application, to use that word, and we take his, if he someone succeed in saying that it is a bail on changed circumstances. The materials before you also show that they are changed circumstances. So alternatively, we'll say on our feet that in the unlikely event that the court says this is not a further application, it is a further application, and then there's no strict procedure as to what we do, we will alternatively pray that this application be treated in that event, only in that event, if the court is not with us, that this application be treated as an application on changed circumstances. And the changed circumstances are what we've already indicated. They have been indicted, they are already before the court, they have been in custody for over 6 months. Clearly, there is no prejudice that will be suffered. We now know that all state witnesses are ready to give testimony. They have offered much more than what was offered in the magistrate court. We would say that even on that basis, this application will still qualify to be an application on changed circumstances. I think that's all. Then finally, there's the last issue I wanted to contribute to, the one relating to non-disclosure. Mr. Judicial has already answered it well. We associate ourselves with that. But we want to submit, my Lord, that that section does not create an obligation on an accused person to give that information if it is read properly. The section 117A subsection 5. I want to give my take, and I believe that that would be the. It says that in bail proceedings, the accused is compelled to inform the court. Compelled. That it doesn't say that the accused shall inform the court. It simply means if you don't tell us, we'll ask you and we'll compel you to tell us. That's what the provision is. Because how does the statute suddenly use the word compel? It doesn't use the language we are all familiar with. If you want to create an obligation, you say the accused shall, a person shall. So this is not an obligation. It's a warning to accused persons that if you don't tell us, we'll force you to tell us. That's what compelling means. So it doesn't say that the accused person shall have an obligation. No. We respectively submit that that is not the correct reading. It is not just to put words into that statute. We are not there. The word that is there is compel, and it's used in the context of compellable. So once you say compellable in criminal procedure, we know what it means. We will force it. So the consequence of non-disclosure would not mean a consideration. The consideration must remain compelling reasons. But again, in the alternative, my Lord, even if it were to be said that there has not been disclosure, I again in the alternative hereby disclose that the accused persons are facing another fraud charge. And that fraud charge is recorded. It's
well, I think there's already disclosure in the state's response. So you are simply saying you don't dispute the disclosure made by the state. It doesn't matter. As you said, it was part of the submissions.
Those will be mine. So we pray for the order in terms of our order is, it says $5,000 US in the draft order, although in the narration it says US 3,000. So we would say that the draft order, I think, we read to the US 3,000. That's what I see. I think it's in, there was a mistake in our in the draft order. In our narration, in paragraph 4, we say that he pays US 3,000, but in the draft order, we then put 5,000.
Yes. Typing over.
Yeah, that's exactly, that was the mistake. But the rest we would apply. We therefore pray that the accused, we wouldn't want to say our accused, but as you have seen the way we proceed, we would think that they rise or fall together. Thank you.
Yes, thank you very much. I have no questions. Mr. Mabawode, I have been sitting all day.
Yes.
It's dangerous for old men to be sitting the whole day. I must be able to stand up, walk about, and so on. And I have not had lunch.
Yes,
it's also dangerous.
Yes.
So I propose that you may respond tomorrow.
Looks to me like Mr. Matuki is committed.
No, it's dangerous for him too. He's an old man. Anyway, on a serious note, what is your response? After 11:30? Okay, very well, thank you. Well, it was just a joke, Mr. Matuku.
I am available, my lord.
11:30 tomorrow? So tomorrow is the 8th. Accused applicants, stand up. We will continue with your hearing submissions on your bail application tomorrow, the 8th of January 2025 at 11:30 in this court. Any other business, Registrar?
No further business.
The court will rise.
No hearing.
Mama guarantee my phone.